9:30, so it's time for the inquiry to resume. So first of all, the usual announcements. Mobile phones, please, if you could turn those to silent. And if we do hear the fire alarm, it is the real thing. So we go out of one of the two fire exits either side of the room, down the stairs, and congregate in the council's car park. And obviously don't come back until it's safe to do. We're told it's safe to do so. Everybody all right with stairs? Yes, jolly good. Thank you very much. Now, I just want to talk. I had a little reckoning, took a bit of time yesterday, reckoning of what's left outstanding. I haven't, unfortunately, got all my notebooks here, but I've just been looking through the last couple of them. And there is quite a lot that was promised from the Section 106 highway session, none of which I've got yet.
I've had an email from...
So I put out,
the email from the programme officers, yep. So I've not had a chance yet. Obviously, two of them are for us, I think, at least two of them, maybe more. But one or two of them are for Kent, I think.
Yes, some for Kent, some for you.
But we'll go over them in the break.
Please go over them, and I want them by next Wednesday lunchtime, please.
Okay.
So there's plenty of time for everyone to see them before the final Section 106 session. Okay. Wednesday lunchtime next week. No excuses, please.
Okay.
Right, next thing. Plans. Right, I have thought really carefully about this issue of how we're going to which plan we're going to show the commitments on, and I understand what the Rule 6 Mr. Barnes has said on behalf of the parish council groups, and I've also taken account of the applicants' comments. In this case, I do understand both points of view, but I think that the applicants have got the better point, and that is that we don't want to end up in the situation whereby something else crops up and the parameter plan is therefore out of date, or at least somebody could say it was, because it hasn't got a certain site on it. So what I would like is the committed sites to be taken out of all of the plans that we've got in our document, and I would like another one which will be an application plan, but it'll be an illustrative one, of the composite master plan. Composite master plan. Which I think is the best one to put them on, because it shows the whole of the two sites, so we only need one plan really, although I should include it in the north and the south if I were you. Yeah. Yes, so that's how I think we should do it. Now, what I would like then, I know some plans won't therefore change, because they haven't all got the commitments on, but quite a lot of them have. So what I want is a complete new set. All right, absolutely. Not just sort of
no.
ones that
I
change.
Get that.
We want a complete new set of north and south in a Dropbox link, which is sent out to all parties. Really as soon as possible. But I think to be realistic, I mean, I don't think it'll probably take very long. But could you do it by next Wednesday lunchtime?
Okay.
Right? So it gives people a chance, I hope. Yes, and then when we've got that, and I would also like when we come back on Monday week to have the two hard copy revised plans.
I'm sure
booklets.
It would. I'm sure it will.
Yes. Bound, please.
Bound, absolutely.
And copies if. I don't know who would like a copy of. I know that. The 5 parishes and presumably the action group would like one. Don't know about anybody else, but I suggest you communicate with Mr. Gearing, and he will organise it.
Could you say that last bit again? I'm so sorry.
I don't suppose everybody wants a booklet of the plans, but I know that the 5 parishes and action group do. And anybody else, I suggest they communicate with Mr. Gearing and ask.
Of course,
So he doesn't go producing
We'll do 4 or 5, say, but if anyone wants to let us know,
well, they
extras.
do.
I'm sure that'll include one or two.
2 for them, one each for them,
Yeah,
and one for
you.
me. And
so that should be all right. But obviously, let us know if anyone wants extra.
all right. Everybody happy with that? So that's when. So really, the deadlines for both of these things are next Wednesday.
And the printouts, the Monday are the session that we're back here.
Printouts, the first session of February.
Thank you.
Finally, the sang note, which we were promised close of play yesterday. Now, I know you've been very busy, Mr. Dygan, with other things. And there's only one of you, I know that. So I do understand that obviously you haven't got it finished yet. But the only thing is whether or not Mr. Bashforth needs to comment on it.
Well, I suspect, given where we are now and the timings of it all, it'll probably be a matter of us commenting in, or him or us commenting in writing by a note rather than orally, if that's. I mean, because presumably it won't be done in the next couple of hours or whatever.
I know, because Mr. Dygan's
exactly, because he's here. So I think that'll be rather than recalling Mr. Bashforth, I suspect that'd be disproportionate.
So what I would suggest we do, I mean, do you think you would? When do you think realistic you could get it done, Mr. Dygan?
Ma'am, today. It's just whether I'm not sure I can get it done by 12.
No, I understand.
But today, like, it's largely drafted, but there are more things I'd like to look into.
No, that's fine.
I think in writing, then, for us to come back in writing, and it could be if it's done today, we could come back by that same deadline that you've mentioned.
Yes,
for
I think,
else.
And I don't really want lots of backwards and forwards.
No.
So if anybody wants to put a response in, because you might want to, Ms. Bonnie, on behalf of the 5 parishes that you raised it, I would like it in by Wednesday lunchtime as well. Okay, and no backwards and forwards, please. You know, I don't want comments on comments. Okay.
Sure,
Ma'am, can I just say something? The note is going to be a factual note, so it won't be a note that sets out the council's position in the light of the facts. So it may well be that we put in something by that same dedeadline to say what our position is in the light of the facts.
I thought that's what Mr. Dygan
said. It's just going to be a factual. It's just going to be.
Might it be worth if it's not, if it doesn't have to be today because Mr. Bashforth won't be commenting on it? I wonder whether it might be good to have the council's both facts and views on the same note. And then we can respond, and then that's it, rather than it.
So there'll be 2 notes.
Or it could just be one note. It could just be a note that sets out what the situation and situation is, and the council's observations on that situation.
Okay, well we can add it. We can add in some.
If that works.
Position on the end of the.
I'm just thinking procedurally to avoid a back and forth and back and forth.
It might not get done. It would be done because we just take instructions on in the light.
Well, look, I tell you what. Would you be able to do it by next Wednesday lunchtime?
Yes.
Fact and views.
Yes.
Whatever you want to put in next Wednesday, right? And then if everybody else could respond to that by following, well, it doesn't really matter before the close of the inquiry, the following Wednesday. How's that? Good. And then there's still inquiry time left. But
yep.
I just want one comment from each policy.
Yep.
No comment on comments.
Mm-hmm.
Right. Is it right?
24th, I think, is that right?
Right. Okay. So, council's note.
Oh, sorry. Apologies.
Is
it's 22nd.
All right. 22nd responses. Try and do it by lunchtime. Right. And then the council's note will be, what was that date again? The next Wednesday.
15th.
Right, midday. Right, okay. Thank you. That's helpful. Thank you very much. Right, that's all I've got. Now, just safe to say about the timetable.
Sorry, Mum, I think Councillor.
Oh, yes. All right, go on, Councillor Bonnie first.
So, a couple of things. And I kind of wanted to alert you to is we've started looking at the stewardship information that came through.
Oh, yes.
Because I think this is coming up in the section 106.
Yes.
Now, this causes a bit of a problem with, I think, certainly for our group, but I suspect for the other group, because there's not a clear way ahead or proposition, in our view, And it also involves parish councils. Now, this is quite a substantial thing, the stewardship vehicle, in our view. And given him that the parish councils, some of them are very tiny, and they only meet every 2 months. And I think we've alerted them to the fact, and they're going to start reviewing this, but I'm not sure we're going to have any clear views on that stewardship vehicle.
Right, well, I haven't looked at it in detail yet.
I suppose the question, Mum, is what your expectations are for the stewardship vehicle in the Section 106. So if I just put that to you and leave that with you to think about. And the other thing is conditions. I understand there might be a new set of conditions, but we've not yet seen them. I think what's in there is the current old ones. And I think there's been some changes, and we obviously need to see those ahead of the discussion on conditions,
Right,
please.
well, I'd like to know what I'm working to. So
Yes, quite.
Are there...
Mr. Digan might be the one to ask. I think, is it right that a new set of conditions are being shared with all other parties today?
I'll check, Mr. Simons. Ma'am, I'm not... certainly there is an updated set of conditions that I've seen yesterday, and but I need to check whether with the applicant in terms of whether they're being circulated more widely.
Well, I think, you know, I mean, they're not secret, are they?
No, not at all.
You know, we all know that it's a work in progress.
I think
But
that we're very... We'll have a chat in the break. I think that my instructions are there's no reason that they shouldn't. In fact, every reason that they should be shared today.
right, I think... all right, okay. Hang on. We need to have what we're going to be talking about.
Absolutely.
And they might have sort of progressed on a bit, but if I'm going to do some sort of track change
Absolutely, yeah.
document to be helpful, then it needs to be based on something which we're going to be talking about.
Well, let's say today.
So can we circulate that today?
In Word doc, presumably, so that you can...
Yeah, so it can be track
editable,
changed, edited.
Thank you.
And I mean, as I would just stress, you know, I send this track change document in good faith without any, you know, it's completely non-committal. You know, it's just that we've got to somehow get through them all. And I think if you've got an idea of what, you know, what I think about some of them, then it's easier
It could
to...
save lots of time.
some time.
So thank you.
You know,
It's all right, I'm used to
please, it's
track-
non-prejudicial. Please don't think...
No. I'm used to track change documents, so don't worry. And finally, I think you asked me for a couple of things, and we'll give those to you for next Wednesday, just for clarity. So that was the NHS numbers and around Duke Shaw, yes.
Sorry,
Duke Shaw.
Oh, yes, that's right.
Yeah. So we haven't forgotten.
No, good, okay. Well, I will, if I've got time, I will actually just go through all my books just to make sure there's nothing. But, you know, there are sort of odd things that people promise something and then it gets forgotten. So
Yep.
if something is picked up after the inquiry closes, then I shall just have to ask for it.
Of course, of course.
Okay, right, thank you, Ms Bonney. Anything else?
I suppose, no, just for completeness, we note and thank you to Mr. Digan and team for inquiry document 100.79 is the LDS note that you asked for.
Oh, yes.
So thank you for that. Obviously, I don't even know whether Mr. Bashforth knows it exists. I think we'll just... I'm not sure that it doesn't... I've read it. It doesn't give rise... I don't think there's anything that we need to sort of say about it at the moment. I think we'll touch on it a bit in closings,
Okay.
but I think we've already covered it in evidence,
we have discussed
obviously.
it, haven't we, to some extent?
Say again, sorry?
We've discussed the whole thing.
We've discussed it, so I don't think... I'm just noting it's there. I'm probably not going to ask Mr. Bashforth anything about it, like in re-examination or whatever, and we'll just leave it for
Up to you.
closings or whatever.
Okay. Anything else? Right, just on to today then. Well, I'm hopeful we might finish by lunchtime. Oh gosh. what a
Remember
faith.
those words.
It's a call to faith, so perhaps we won't. Oh yeah, not. Oh, you're grimacing there. Right, okay, fair enough. Right, so we've understand that Mr Young has questions for about an hour, but I suppose, yeah. So he'll do that first. I'll ask my questions. I have got a few,
Of course.
I'm afraid, but hopefully not too long. And then you'll do your re-examination.
Yes, thank you.
And then that will be it for the day. All right. So, Mr Young, if we have a break at about 11 o'clock.
Yes.
Please. So, oh, actually, you might be finished by then, mightn't you? Yeah. Yeah, okay, we'll break at the end then. Right, thank you.
Thank you very much, Madam. Mr Bashford, good morning.
Good morning.
Thank you very much for accommodating me in this way. You've all had to come back, so thank you to you and the inquiry for that. Right, so the position is that obviously my clients have identified the Northern Relief Road and the Southern Relief Road as infrastructure in their local transport plans, haven't they?
Correct.
And plainly, they are desirous of that being delivered, aren't they?
That's their position, yes.
Yeah, and at the moment, there is no other means by which this is going to be delivered other than by your client's proposals. That's correct, isn't it?
At the moment, that's my understanding, yes.
Yeah. There is no public money or money earmarked or HIF funding or anything of that kind that's been identified.
Not that I'm aware of, no.
No, so the only show in town, as my learned friend would put it, the only show in town is your clients delivering these roads through these proposals, yes?
Yes, and no funding at the moment, yes.
Yeah, and therefore, obviously they promoted it through the local plan process, but without revisiting all that, that hasn't culminated in an adopted plan. There doesn't appear to be a timescale for a new adopted plan. So your clients decided to take the initiative and submit planning applications, yes?
Yes, although I think the council, the document that Mr Simons was talking about is a timetable for it, albeit we had comments on it on Wednesday. So.
Yes, yeah, but optimism would be needed in a large dose, I think, given the track record up to date about the delivery.
I wouldn't disagree with that statement.
No. And as a consequence of which, what I'm focusing on, and I'm getting your agreement, is that your clients are the mechanism and the means by which this road is going to be delivered, yes?
Correct, which is a good thing.
Yeah, add whatever publicity you want to it, but I don't think anybody's doubting that. That's why it's in the local transport plan. The position is the roads. As far as my client is concerned, there is obviously absolutely no questioning of the merits of the road, because that's why they're in the local transport plan, isn't it?
Yes, of course.
Yeah, it's plain to see, and we've seen it throughout this inquiry, there's a congestion problem in the centre of Sittingbourne, isn't there?
There is, yes, it's in the local plan as well.
There's large-scale significant development that's been identified and being built and has been built to the north of the town. That's right, isn't it?
There's been a lot of development around the town, not sure just in the north. So.
Yeah, a lot of employment is what I said. You can see for yourself, there's a concentration of employment to the north of the town, isn't there?
There is the Eurolink development.
Yeah. I'm not trying to trick you into where it's going. It's obvious where it is. There's a science park proposal in the south, and that's part of your client's proposal, isn't it? Further employment down by the motorway.
Right.
Yeah. So what we've got is a situation where there's a congestion problem. There's large-scale employment, as my little friend cross-examined Mr. Digan on. This is a growth area, identified for growth, yes? Nobody, certainly from Kent County Council, is questioning the merits of the road. Indeed, the merits of the road are obvious, aren't they?
They are, and also in agreement with National Highways as well.
Yeah, and the obvious point about it is, if you happen to know the Medway towns, as some of us do, you've only got one way of getting from the M2 to Sittingbourne, which at the moment is on the eastern side. So anybody travelling to the western side, on the western side, anybody travelling to the eastern side of the town is inhibited in that. You either got to take a very lengthy circuitous route via Faversham, or you've got to come in on that western side, yes?
I agree, yes.
Yeah, so in terms of completing the local road network and having a fully functioning distribution and an efficient distribution, so people aren't travelling down the A2 unnecessarily along the length of it. Obviously, these new roads are going to help secure that, yes?
Correct.
And once you build roads at this scale, things like the Science Park, the development to the north, they take on, if you like, an energy of their own, because the roads help facilitate quick and easy access to the trunk road network, don't they?
Right.
Yeah, good. Okay, so we're all agreed about that. Where we disagree, obviously, is the figures. We've got different figures about what the road will cost, and that's been fed into viability work, hasn't it? Yes?
It has, and again, other witnesses have explained that. So I wasn't necessarily at all of those different sessions.
Yeah, and
again, I'm just looking at the planning balance, not the figures. So just to be very clear.
yeah, Mr. Bashford, you don't need to put in the defence before I've asked. I've simply asked you about the fact there's a dispute, and you probably have appraised yourself of the fact there is a dispute between Kent and your clients as to the figures surrounding the costs of the road and the viability appraisal work, yes?
Yes, I have seen the sort of barrister notes between that sort of
Yeah. I am not going to cross-examine you on issues that have been questioned, and you can put that entirely from your mind as to the detail of that. You know, we have our evidence, our experts, what we say is realistic, yours is different. On your case, and you'll know this as well, on your case, it's all afforded by the developments, it's all viably it's all viable. It can deliver the affordable housing, it can deliver the infrastructure, and it can deliver the roads. Yes, that's your case.
I believe so. Yes.
And highly significant to that is obviously the reassurance that it is sought to be given by the delivery of the roads before a single house is occupied. So before houses on the northern site are occupied, there is the reassurance that the Northern Relief Road will be built, yes?
There are triggers there, yes, in 106 and conditions.
But just to be clear, and I'm not trying to trip you up, it's on occupation. I'm not saying it's anything else, but not a single house will be occupied until that Northern Relief Road is opened. That is your case, isn't it?
Correct.
Yeah, okay. And that's really important, isn't it? To give the reassurance that the road will be provided, your clients and you, I'm sure, attach significance and importance to that, don't you?
No.
Okay, so your view is...
So sorry, can I
yeah, go on.
qualify my answer? I'll explain. So
No, go on.
So we discussed this earlier in the week. I don't know if you were here all of the time, but part of it.
I've seen the tape.
Yes. So I think one of the things, the issue, where we are, if you like, is what you do with the information on your clients. I completely understand the concern, if you like, in terms of they've some experience from other developments. As you say, it's a priority for them. But it's what I do as a planner, if you like, and again, we've heard Mr. Dyker's position, which I agree with. It's a case of I can't use that as a 38.6 in terms of the planning balance, if you like. There's case law in respect of that and everything else. So there's lots of discussion about costs and viability and everything else, but it doesn't go to the merits of the granting planning permission for either scheme.
Okay, that isn't my question, but we'll try that again. Okay, I'm happy to put it to you again.
But I
The
did
fact
answer,
that-
I did answer your question, though, sorry, just to be clear.
Yeah, the fact that, well, we'll just try this again. The fact that the road, the Northern Relief Road, that's all I'm talking about at the moment, the fact that that road goes in before a single house is occupied is important, isn't it?
Not in the planning balance.
Okay.
It's important in terms of the orderly delivery of those things, but it's not in the overall planning balance. That was why I was qualifying what I said.
Okay, it may be my fault. Let's see why this might be important then from a planning context point of view, okay? In terms of my client's recent experience at Chilmington Green, what they've experienced is housing is being built and then infrastructure not being delivered. You're probably, in a general sense, aware of that without the detail.
I am aware of that, and it's a very different situation, as I understand.
Yeah, and...
Spade a spade and ask where you're talking about, please. I just wanted to know where you're talking about.
Chilmington
I
Green.
thought it-
Sorry, yeah, Chilmington Green, forgive me. Okay, and that is causing a very significant headache for Kent County Council and others. I think the latest is the developers declared bankruptcy, their injunction proceedings, High Court proceedings. There's been an appeal. The appeal hasn't been determined. There's all of these things, and the Kent County Council has concerns. The beauty of putting the road in and ensuring the road is in before any of the houses are occupied means that your clients, or whoever delivers this scheme, they might sell it to Urban and Civic or somebody else, but whoever delivers this scheme has to put the road in first. That is important, isn't it?
It's about the sequencing of the development, but yes, it's not about the viability or the deliverability of the road.
This is a separate consideration before we turn to viability. This is about making sure that your clients, or whoever develops this site, does what they say they're going to do, okay, which is a legitimate concern for public authorities. By putting the road in first, before a single house can be occupied, it guarantees delivery of the road, yes?
Yes, and that's what Section 106 triggers will do and ensure the orderly development. But again, it goes back to the point, and again, this has been discussed in the inquiry before. If you don't do the scheme or it doesn't get delivered, so the road is it has to be done first. If that doesn't get delivered, the harms from the other things don't happen either. So again, very basic principle.
Yes, and I know, and I do understand you're coming back to the planning balance, but we're just putting the building blocks in place. I'm not questioning you about the planning balance. I haven't got a planning witness.
I am the planner, that's why
it is one of the things planners do, yes, but that isn't the only thing planners do. They don't just...
It's quite important.
It's,
I take the evidence of others and then decide where that sits in the balance.
Mr. Bashford, I'm not going to sit here and tell you that your job is pointless, okay? I'm not. I'm sure that the balancing exercise is a terribly important thing, and the Inspector and the Secretary of State are going to do the same. But you do have a few more skills. You're just being a little modest. Okay? Right? So one of the things we do is when we advise people and we look at schemes, is what we do is we think about what might be important to make sure that there is trust and there is understanding and that everybody is comfortable with what's being proposed. And your clients have reached a conclusion, a agreement with my clients over the highway impact proposal of the northern site, haven't they?
Correct.
Yeah, and that has been predicated on the mitigation works and infrastructure works that are being delivered, yes?
Yes, in terms of they've agreed that it can work.
If your client said, oh, well, actually, what we want is 500 houses on the northern site, but we don't want to deliver the road not until we've got 500 houses away and we've got the revenue from that. That would be a different case from this case, wouldn't it?
Sorry, just repeat the question again. So it wasn't very...
Sure
follow.
Okay, and it's entirely my fault, I'm sure. Okay, your clients, as we know, are going to deliver the road before there's any occupations on the northern site. We've agreed that.
Or the planning permission to ensure it's delivered. That's slightly different.
So the houses themselves, you are aware, obviously, are not to be occupied until that road is built. You are aware of that?
Correct.
Yeah. Your client is nodding. You shouldn't really be doing that, but it's helpful on this instance, okay? Right. Now, there is agreement. We've already agreed this, but there is agreement between my clients and your clients as to there being no highway objection, yes?
Correct.
There is traffic generated by the development, and there is other traffic in the area where the northern site is, yes?
There certainly is traffic, yes.
Yeah, and the solution that's been agreed, that's led to that agreement, is the delivery of the Northern Relief Road, together with some other works.
Yes, the sequencing of it, yes.
Yeah, so the Northern Relief Road is fundamental to the agreement on the northern site coming forward.
It's important for the...
Just a yes or no to start, then qualify it by all means.
Sorry, ask the question again.
Yeah, so the delivery of the Northern Relief Road before the development opens, before it's occupied, is very important, isn't it?
Yes, it has to be delivered.
Yeah, good. Okay, and we don't have disagreement, because if your clients were, and this was my point and probably inelegantly put, so forgive me, if your clients were saying, oh, well, actually, we want 500 houses and the revenue from that the houses are sold beforehand, this isn't a master developer model, we'll come on to that later, then that would be a different case. But you're not asking for a trigger at 500, you're asking for a trigger at 0.
Correct, although I understand that's part of the issue with Chilmington Green, that effectively it started before a lot of the big infrastructure. So again, sort of comparisons,
And that's precisely why it's important, because we've highlighted the concerns about Chilmington Green. It's taking up a huge amount of resources on the part of the Kent Council, not just the lawyers, but everybody else. Kent County Council would like to avoid that. The scheme for the north, where the road is delivered first, overcomes that concern, yes?
It does, and again, in some ways it shouldn't matter about the cost or deliverability of that, because it's effectively a gateway to say, actually, once that's been done, you can occupy the houses. So,
Yeah, absolutely.
So, the detail of the viability, however that works and everything else, it's going to happen.
Yeah, there's a strong safeguard in the Section 106 that requires the road to be opened first, yes?
Correct. And that's why it's different from the likes of Chilmington Green and the concerns that clients have.
So the inspector can record and the Secretary of State can record that we are agreed, as we have, that that's very important, that that is part of the scheme, and that will have been recorded in your answers. And then looking forward, what we know is the delivery of that road is not straightforward, is it?
I'm not sure. Well, I'm aware of the evidence of that, but I don't think that.
About the north.
Yes, no, that's all I'm talking about for the first half an hour.
I'm aware of. There's been lots of discussions of those things, but that's not unusual.
It's not straightforward in the sense that many of the sites that you and I do in different, I don't mean together, I mean just elsewhere, up and down the country, the sites that we do don't always involve a compulsory purchase order, do they?
No, and there may not be one here. So again, most of the time, it's not a planning consideration.
Yeah, you're working on the assumption a CPA won't be needed.
I'm not saying anything about CPA. I'm not saying anything about deliverability, land ownership, or other things. It's not relevant to a planning consideration.
Okay, we disagree about that. You've explored that with Mr. Pereira. You've been to the Wimbledon case. He's taken you to the bits of the PPG that relate to strategic sites. I'm not going to rehearse all that. That's fine. My question, though, was really very specific, which is that in terms of the Northern Relief Road, do you or don't you think the delivery of that is straightforward?
I've heard evidence on it. I don't think it's any more unusual than any other big sites.
Okay, I'm going to suggest to you it is, because what you've got is a series of land ownerships and Network Rail, all of whom have got to be dealt with, haven't they?
Again, that's not a relevant planning consideration. And you know,
But just humour me with the answer to the question, that you've got different landowners and you've got Network Rail, all of whom you've got to deal with.
Yeah, but so what from a planning perspective?
Oh yeah, it's the so what case. It doesn't matter, it doesn't affect your planning permission, and it doesn't mean that you shouldn't have planning permission,
Yes.
okay?
And you mentioned Network Rail. I think we have got certificates and things showing actually there has been good progress with that.
Yeah, absolutely.
That's what you'd expect at this time in terms of where we are in the planning process.
Yeah, absolutely, and the
Again,
gentleman...
Same with the land ownerships. Again, it's not a relevant planning consideration, but again, I'm seeing nothing unusual or some big red flags. This is something, there's something big, but actually I don't need to take it into account as a planner in the planning balance.
Yeah, but do you remember that the gentleman from Network Rail was here, wasn't he, at the inquiry? Were you there on that occasion?
Only in respect to 106, I think.
Yeah, he was very clear to make clear that what was they were happy with the operational aspects of it, and the operational aspects of it are building a bridge over the railway, yes?
I think so. There's some documents that show that they're kind of there's been good progress made with
Yeah, absolutely, and nobody's, I think, suggesting, and we're not suggesting, and it would be a matter of concern to us if there were operational concerns relating to the delivery of the road because of the height of the bridge or the train. Nobody is suggesting there's some technical control or constraint that means the road can't be delivered.
Right. There's no planning objection to it, and maybe, again, there's a whole property thing which needs to take it, the course it would all...
Yes, that's very fairly put. Okay, and then you've got, obviously, Trentport, and their land is outside your red line, isn't it?
Some of it is.
Yeah.
I think there is overlaps, isn't there?
Yeah, no, you're quite right. That's quite right. And then there's the area of land that is this open space. It's being investigated to see whether it's actually sang.
Yeah.
Sang as an issue is not insurmountable in the sense that there will be other sangs, and if land is taken and it's no longer considered to cover the same area of sang as was required, or it disrupts it so it's not effectively a sang, there will be other locations where sang can be delivered. Yes?
I think I answered the question in a similar way on Wednesday, I think. So
Yeah.
I think, you know, and actually, there's nothing in planning terms that requires it to be delivered anyway. So, but you're right, there is all. It's not as if it's your starting point. There is a SANG, and then it has to be. It's not an insurmountable challenge from a planning point of view. That's the key point.
Yes.
Planning we're talking about here.
Yeah, I don't know what the note will say about whether there's anything in the planning permission that required a SANG. It would be very odd to require a SANG if you didn't need one.
Well, Mr. Dygan's already advised on that, and the inquiry may have missed that, but he did say nothing in the conditions in Section 106. And again, having looked at both things, I think that is the case as well.
Yeah, it is. It's a bit curious why it's called a SANG if it's not a SANG, and it's a bit curious while Natural England will be interested in it, but if it doesn't trigger the need for a SANG, then and that's what the evidence shows, and that's what the ecological reports show, then I'm sure that's fine. But the point is, we've got this land, and of course, your client doesn't control that land at the moment, does it?
Again, just
Just a yes or no to start
I
with.
don't know the full ins and outs in terms of controls. That's to be quite honest.
Okay.
I'm not a planner. Haven't done land reference or anything else. I'm aware of that there is overlapping there. I'm aware of Section 106 agreements which allow provisions to sort of draw down that land, if you like. And I think that was agreed with your client.
Yeah, I'd be surprised though if a planner leading a project as you are. I presume you're leading this.
Well, I don't know if the word leading it is. I've looked at it and
Okay.
the evidence, but yes.
You're giving evidence on behalf of your clients, the planner. You brought all the other evidence together in your planning balance, yes?
Right.
Yeah. In doing that exercise, what you probably want to satisfy yourself of is that that road, which we've agreed is very important for the delivery of the northern site, can actually be delivered. Have you satisfied yourself of that or not?
Different test. Again, it's different. If I was at a CPO inquiry with a very different test, I'd be saying yes, I need to understand that. But from a planning point of view, it's not about whether it's deliverable or not.
Okay, what's the answer to my question though?
Sorry, can I answer the question?
Yeah, my question was, have you satisfied yourself that that road is deliverable?
No.
No. Okay, that's
I'm
fine.
a planner. It's not something I need to do, if you like.
Okay,
So
all right,
that's
but-
to say, if I was at a CPO inquiry and going through the test there, that's a different sort of test I'd have to go
Yeah.
through.
Okay, and we had the evidence from Mr. Mitford Slade, who hadn't made allowances in his viability appraisal for the acquisition of the land, and further all your client, Mr. Gearing, confirmed that, and so on, and that's not included in the appraisals. I don't want to revisit the numbers because that's not what this session is about. What I'm just interested in is the issue of what you say in your proof about phasing and delivery. So can we turn to page 12 in your proof of evidence? Page 12, I've got it, so I've got the hard copy. Yeah, great. And what you say is, due to its strategic nature, and nobody doubts this, this is a strategic site, and you've not argued over what... I'm ever sorry, page 12 of Mr. Bashford's proof. Oh, 3.10, sorry, phasing and delivery. So due to its strategic nature, and just to say we don't disagree at all, this is obviously a strategic site, nobody would argue otherwise, is that right?
Correct, yeah.
I'm talking about the northern site, obviously. The proposed development will need to be developed in phases, and then you say for the northern scheme, years 1 to 3, movement corridor and early landscaping buffers around the development edges. So that's the actual work that's involved, yes?
In very broad terms, yes.
Yeah, years 1 to 5, phase 1 housing, the primary school and sports facilities, and then 5 to 10, phase 2, the housing. Now, you forgive me, did you identify how much of the housing was going to be in years 1 to 5?
No, although there is evidence in front of the inquiry on that. So,
just broadly, help me out if you will. Is the lion's share of it, the majority of it, in phase 2?
let me have a look.
Okay.
Best thing to do
Okay.
rather than me speculate. I'm going to look in. What was quite helpful, again, I'll give the CD references. I think in response to the NHS, there was a kind of a profile done of how the housing could come forward. So it's probably, if I just go to the NHS letter, so it would be one of the last IDs. Yes, it's the quad letter in there, and there's appendices with a kind of a delivery schedule in there, if you like. That's probably most helpful place to go to. Again, it's illustrative, obviously, but it is 71, correct?
100.71, if that helps.
And if you go to PDF, I think it's page 14, and this is why it's probably quite good to have a zoom function on the, because it's quite a small table. So again, this was, I must stress this is illustrative, but this is what, yes, exactly, you have to zoom in. So you can see there, year 3 construction. Sorry, it's Northern's at the bottom if you're there, madam. Yeah. So this, just for context, this was provided in response to requests from the NHS, particularly for the doctors, etc., on site, just so they could understand the phasing of the delivery of the homes. So when they would need to provide doctor surgeries, that's what was provided. But again, it's useful for this purpose as well.
It'd be 250, wouldn't it, actually, by year 5?
Yeah, so yeah, correct. So in terms of illustratively there. So.
Yeah, good. Now, those are obviously not identified as specific years. You haven't put them as
No.
somehow year 1 is 2026. First of all, we don't know when the decision will be made. Do
Yeah.
we?
Oh, sorry, just to say it, that there is some years at the top, but
Yeah. Sorry. So your year 1 on your proof, does that correspond to next year on that table?
I don't know. I mean, you can see there's some preliminary work to be done, but again, assume it depends when the decision is, as you say, Mr. Young. So yes, sometime next year, perhaps.
Okay. So okay, and then so by year 5, does that say housing by 2031?
It's 2030 here, but you know, there or thereabouts.
That's for the 250.
250
Yeah,
according to this
okay.
table,
All right.
yes.
Okay, because obviously the roads, we want to know when the roads are coming, and so the roads are self-evidently entirely dependent on the housing.
Yeah.
The housing is entirely dependent on the roads, and so we need to know how the whole thing works. So, just thinking about this, you may not know this, but George Osborne in the 2016 budget identified that ministers would take no longer than 3 months upon receipt of the inspector's decision to issue a decision. And the reason the inspector is raising an eyebrow is that we sometimes find that doesn't happen. What I find is that you write to the minister every 6 weeks, reminding them of what George Osborne said. That can help, but that can help. I found that very helpful. Different Secretary of State, obviously. We don't know. But unlike what Mr. Pennycook issued yesterday, reminded us, didn't it, that unless it's expressly revoked by ministers, then whatever previous ministers said, whichever political party stands. So on a reasonable...
Sorry, is this the letter to inspectors in terms of the local plan thing?
Yeah. And what he was keen to do was point out, remember that letter from Mr. Bowles, Nick Bowles? He said, I'm expressly revoking that. And so we probably all have forgotten about that letter, but now we haven't, and that one's gone. I haven't seen anything to suggest that ministers would want to take any longer than 3 months with the decision after the inspector has issued her report. Have you?
I haven't, but we all know that decisions come out in different times. I've had ones that come out short of Secretary of State decisions. So yes.
Yeah, well, we live in hope. And as a consequence of which we might assume reasonably that allowing, obviously, for a very big inquiry, the inspector's report and the Secretary of State's reporting, we might see a decision by the summer of next year.
Yes, I've got no reason.
Yeah, it seems a reasonable timescale. Of course, it could take longer, might be quicker. Yeah, could be. Indian summer, November. But let's work on summer 2026. Now, let's imagine there you are with your clients. You've received a planning permission. Mr. Simons knows who was in this one, so he won't be looking at the appearances. He'll just be looking for whether the Secretary of State's allowed it or not, and obviously what the inspector recommended as well. From that point on, of course, your clients have got a planning permission that they've got. If it's approved, sorry, I forgot that. Assuming it's approved, if it's not, then you won't be celebrating. But if it's approved, and we don't know, quite rightly, what the outcome will be, but if it's approved, then your clients have got to think about implementing that in line with all the commitments they've made in the obligations and the planning conditions, yes?
Correct.
Yeah. So the submission of the reserve matters for the northern site, how long have your clients asked for that?
I don't know at the moment because it's not, again, we'll get onto this into conditions and things, but...
Really? At this stage in the process, you're not clear how long you want for reserve matters?
Well, obviously we'd like from submission to determination in less than 6 months, but again, it depends on the triggers and conditions and everything else. So.
Yeah, sorry, when you said 6 months, what I'm talking about is what the condition says, because clients and developers always say, oh, yes, we'll put the reserve matters in quickly, but it's generally better to look at the legal parameters of that. So
there's discharge of conditions, there's all sorts of things to go through as well.
3 tiers, isn't there?
Yes.
Just so everyone's aware, there's no, you wouldn't know, Mr. Young, Mr. Bashful wouldn't know, the timelines for RMs is something that actually is happening, it's a discussion that's ongoing at the moment between Mr. Dygan and my client, which Mr. Bashful's not involved in because he's here. But in terms of what the conditions will say, that might not be what you're asking, but just in terms of what will be in the conditions, just so, and obviously we'll come back to that in a couple of weeks' time.
Because some clients will look to expedite the period for the submission of the reserve matters. They'll follow paragraph 81 of the MPPF and they'll ask for a reduced period. And some local authorities will ask for a reduced period. I haven't seen anything, of course we can always look at other things before the end of the inquiry, I haven't seen anything that suggested your clients wanted any longer on the northern site than 3 years to submit their reserve matters, have they?
Sure, Mr. Dygan would be apprised of what the up-to-date situation is.
I'm just asking Mr. Bashford just what his position, his understanding is.
Sure, fair enough.
I'm very happy to turn up the draft conditions, but recognising that's what I'm not involved with currently. The discussion.
We can only.
I know there's an active discussion about timescales for implementation and everything else, so I'm very happy to turn them up.
If you wouldn't mind, I think it'd be useful just to understand where we are, and then obviously there's going to be a discussion about this.
Right. Okay. I haven't got my.
I'm happy for the witness just to record what he knows is the current version of the conditions.
Yeah, well, have we got it online that we can just at least have a look? Otherwise, I'm going to go and get mine. Just next door. Because there's a phasing, isn't there? So.
Yeah.
I think
there is a version online, but I think why I'm not looking at those is because I've been probably looking at more up-to-date versions, but I'm very happy to go back to what's online.
Well, it's all right. I mean,
just tell me your understanding.
Okay, you
the latest
say.
version you've got.
So this, again, just with the caveat that I haven't seen what's been going on this week, and there obviously is active discussions this week. So it just says that condition A3 of the version I've got says reserve matters pursuant to condition A2 shall commence before the expiration. Doesn't even look right. Shall commence before. That should be submitted before the expiration of 3 years.
Yes.
Yeah.
Don't worry about those problems. I'm sure they'll get ironed out.
Yes, I'd hope so.
You'd rather assume, despite the drafting error, that it will be submitted within 3 years,
Correct.
which is the standard period.
Yes.
Is that for the whole site, or just one phase, first phase?
Reserve matters pursuant to A2. So A2, first application, all self-applications should be made before 10 years of date.
It's the first. It's basically the first round of reserve
Again,
matters.
I think 10 years is the final phase. isn't it?
Exactly. So,
Well, that's what you're proposing. I'm not
Yes.
sure. That's-
the first application will be made no later than 3 years. So that's condition A2. So it is consistent with that. So.
Yeah.
Yes.
So the situation is, let's imagine 2020 planning permission, if it's granted, is in the summer of 2026. You've got to submit your first phase reserve matters within 3 years of that. So that's summer 2029. Yes.
Correct.
Okay. All right. Now, you don't need to have completed the Northern Relief Road road to submit reserve matters at all. In no way are those two linked, are they?
Not as I understand, but again, I haven't seen the detail of the drafting of that. But yes, there should be, in theory, be allowed to be some parallel working, if you like, in terms of the road can start and then approvals can be sought for the housing, but you can't occupy it.
Yeah, and then we don't know how long the reserve matters take. It might take 6 months, it might take a year, we don't know what there's to be discussed. But once the reserve matters for phase 1 have been approved, it will then be subject to a separate condition, which is probably one on the outline, that requires there to be a commencement on site within 2 years of the approval of that first phase of reserve matters. Oh, sorry, yeah.
I don't think there's usually, well, possibly, I don't know. So.
Generally, that's what happens when you submit a planning application and you get the reserve matters, then the reserve matters are approved and you've got 2 years in which to implement.
Correct, and that's what I was reading earlier, so it's 3 years actually. So.
3 years for the commencement on site.
Yes, so I was reading it wrong. So the reserve matters pursuant to condition A2 shall commence before the expiration of 3 years. So that's your
okay.
point. Yeah.
So I'm going to be optimistic and say 6 months for the approval of the reserve matters. So that takes us to January 2030, and then 3 years after that would be January 2033. Now, again, you don't need to have actually built the road by that stage.
Just go back on those timescales. What's those timescales for?
So summer, I'll go through it in stages with you. Yeah. Decision, if positive, summer 2026. Yes.
Yep.
Submission of the first reserve matters 3 years later. So that's summer 2029.
Why 3 years? No, that logic doesn't work.
I'm ever sorry, I thought you said the condition said that.
No, sorry, you mean that, but that's, you have to submit by then. You can submit a lot quicker than that.
Oh, absolutely you can. And if you want to reduce that, you want to say, well, some of my clients do, we'll submit that within 6 months, or we'll submit that within a year, go for it, because it's in paragraph 81. But at the moment, that isn't the case, okay? So I'm just going on what the actual legal default position is.
We'll discuss that.
Oh, yeah, of course. But what I'm trying to say is you could submit within 6 months or 4 months.
Nobody doubts that. And if you want to back that up, rather than just say that...
That's effectively the backstop.
Yeah, I think everybody... I'm sure the inspector understands how it works, but what we're doing is just testing the legal boundaries of your case.
Yeah. But that's when you must have submitted them by.
Yeah, don't worry too much about, resiling from your legal position on those conditions at January 2023 to make a material commencement. We all understand that you might do it quicker, and it's up to you whether you want to reduce those timescales. But my point is...
I mean, it's very... Just to be clear, though, it's very unusual. I mean, we have cases where, things have been delayed for some reasons, and people do submit at last minute, but it's quite unusual to do that. You wouldn't wait until close to the 3 years. You tend to do it a lot quicker than that.
Yeah, you might do, but what I'm dealing with is the legal parameters of your case, okay?
That's a worse case, though, because you have to submit them by then.
We can debate this for an hour, or you can just agree the timescales with me on what the legal timescales in the planning permission are. It's 3 years to submit that. That's how long you've been given.
You have to have submitted them within 3 years.
Yes.
But within is the important word. Within.
Yes, absolutely, yes. You could do it the day before, or you could do it a week after you get planning permission.
Correct, if you've done lots of work and everything else.
Absolutely, yeah. And obviously it's open to your client to consider reducing that 3 years to 6 months, isn't it?
Yes, and again, there's all of the other things you need to do in terms of discharge condition and everything else. So it's not just reserve matters are an important part of it, but there are other things to do as well.
Yeah. Now, I'm not trespassing on whether your clients are going to reduce those time periods, particularly on a phase development where it's only phase 1, so that we might expedite the process to deliver the houses and deliver the road. I'm not going to ask about that debate that's going on. What I'm just doing is what the planning permission, the latest version that you've got says. So that takes us to summer 2029 as the backstop date.
Yeah, as the backstop,
6 months for the approval, could take longer. That takes us to January 2030, and then you've got 3 years, not the usual 2, but you've got 3 years for a material commencement, yes?
Of those reserve matters.
Yeah, so that's 2033, and that doesn't mean you have to have built a house. That just means you've got to do the necessary works, the footings and so on, that would trigger and protect the planning permission, yes?
In theory, yes.
Yeah.
But again, backstop, these are worst case.
Yeah.
Worst case.
Now again, and the reason I'm interested, my clients are interested in this, is that actually you don't need to have built the road by that stage, do you? By January 2033.
No, you don't have to have built it, but the reality is there's a financial incentive for you to do that if you want to get on and do things. So yes, I mean this is very theoretical.
Absolutely, but it is also, we're looking at the four corners of your actual planning permission from a legal, a legal perspective of what's allowed. You may well look to expedite that 3 years and reduce that and reduce the commencement period as well. Because you could do that, couldn't you? You could reduce the commencement period from 3 years to 6 months.
Yes, and what you tend to find with clients, I certainly have this, is you tend to submit to the reserve matters, and then it's because you want to get it.
Yeah.
Once you've got these discharge conditions, you tend, here's my final design to approve, and then once that's approved. So the whole point is you are getting on with things. So.
Yeah, and you're not aware of your client in any way wanting to push those 2-3 year periods back anymore, are you?
Again, I haven't been party to discussion.
Okay,
they are standard sort of things you tend to have. So
yeah, okay. So I've got January 2033, and then we've agreed that you don't need to build the road. When you actually build the houses, if you've made a material commencement, doesn't matter, does it? Unless you are faced with a completion notice, which are as rare as hen's teeth. Unless you get a completion notice, then the actual building of the houses isn't prescribed by the planning permission, is it?
Sorry, just ask that.
Yeah. Once you've made a material commencement, the planning permission has crystallised and been preserved. Do you understand that?
Correct.
Yeah. So when the
subject to the triggers and everything else in the Section 106 and conditions there.
Yeah. When the actual houses are built and ready for occupation, is not subject to any controls in the planning permission or the conditions. The only way at that point would be if the council decided to issue a completion notice.
This is why I'm slightly confused. The reality is you can't occupy the homes until the road's built.
Don't worry about the road for a minute, just focus on my question.
But that's really important in terms of the sequence of the planning permission and how it works.
Yeah, I don't doubt that it's really important, and I'm particularly interested in it, but what is my question is separate. Once you've made a material commencement on site, yes?
Yes.
Yeah. What's the mechanism then to ensure the houses are actually built?
There's nothing to make sure they're built, but again, it's an orderly things. But again, you wouldn't bring forward or start building things until you know they're going to be, you need to make sure that you're building something and you're going to occupy it.
Yeah. But sometimes people put in the access way or the houses, and then they come to lawyers and ask, is that enough? Because I don't want to lose the planning permission. That's what a material commencement is. That's what the January 2033 date would be. It isn't actually the building of the houses. What you're saying is once you've started building houses, you're going to want to finish them, yes?
Well, of course you are, yes.
Yeah, good. Okay, but we don't have...
That's the same with the road as well, though, because again, I'm not close to the Section 106 drafting, but I do think, I do understand, again, Madam Minister will come up in the 106 session, I do think there is provisions in the 106 to almost, when you start, there's kind of, I don't know how this has evolved, but there's things like discussions about bonds and things like that to make sure that, you don't suddenly start and then stop, if you like.
Yeah, absolutely. But that's the roads. I'm talking about the houses. With the roads, there are separate concerns about, whether you start the project and then you don't finish it and so on.
And that's addressing your kind of Chilmington problems or concerns, if you like.
Yeah.
And again, goes back to the harm piece about if there's no development, there's no harm. But actually, I think, again, I'm not sure how those progressed in the 106, but that addresses that point, if you like. So.
But just thinking about the timescales for the northern side and the road, what's got to happen with the road at the moment is that your clients might be able to negotiate and acquire an interest on the land that is going to pass to Swale. You might be able to do it by negotiation, mightn't you?
Yes, I would hope you could. But again, I'm not an expert in these things, and there's been discussion about a reasonable public authority, and it's important for the delivery of potentially the whole strategy for the borough. So,
and you heard Mr. Dygan's evidence, I did as well, that it has to be an appropriate price.
Not a planning issue.
Okay, and then you've got to deal with Tremport, and you've got to acquire, your clients have got to acquire that interest as well, haven't they?
Not a planning issue.
Yeah, okay, and then they've got to resolve the issue with Network Rail.
But not unusual, these positions, though. Again, I keep saying these. We've just talked earlier about complex sites. These are very common things, are not insurmountable, and they,
This is a
They get sorted out outside of planning.
Yeah, this is a large, complex site, isn't
Yes,
it?
but it gets sorted
Good.
out outside of planning.
Yeah, this is a large, complex
Not
site.
a planning issue, though, Mr.
And I know you're very keen to say that,
Yeah.
and I understand it, and I'm sure the inspector understands it. But what we are looking at in terms of this proposal, what my clients are interested in is the sequence of events in which the roads get delivered, because that's what they want to see delivered.
Yes.
And the
But
position...
that's why, just to be clear, that's why 106 has those, again, I'm not one for that discussion, but that's why I think your clients have been seeking that reassurance. So, because that's what's important to your clients in terms of the roads.
Yeah, and what's important to your clients is that if you can't acquire the land, because there's no guarantee that you can, and there's been no evidence that you made any progress towards that in acquiring any of those interests, your clients have been keen that my clients, including the Section 106 compulsory purchase powers, yes?
Not aware of those discussions.
Okay, well, I can tell you that they are, and the only way this happens if you can't acquire those interests is through a CPO. Are you aware of that?
I'm aware of the CPO process, yes.
Yeah, and
That's if it can't be negotiated.
if it can't be negotiated, yeah. The only way this happens, if it can't be negotiated, is a CPO, yes?
Yes, again, not a planning issue.
My clients can't tie the hands of the members to agree to the CPO, but the wording of the Section 106 indicates that they'd be willing to engage in a CPO process, subject obviously to what the members decide. So, you presumably, without any real experience in it, don't know how long the CPO process takes, do you?
Again, not a planning issue. So.
No. So, in reality, whilst you say, the completion of the houses, which we don't have any legal control on, but certainly the commencement of the development, anyway, of the first phase, pushing into 2033, the road might take that long as well, mightn't it?
Not necessarily. Again, I've got some experience of compulsory purchase, and what we have done in the past, and this is where it interacts with planning, is we have submitted reserve matters before any compulsory purchase. So you're not necessarily losing that much time in terms of, you can still get on with the planning process while there is a separate compulsory acquisition. And that sometimes, again, this is my own experience of things, but that sometimes helps in terms of providing the certainty about here's the route and making sure you know exactly where you're, which land you're taking. So.
And very helpfully, you're just confirming there exactly what I put to you 10 minutes ago, aren't you?
Sorry, what's that?
So I put to you that the road doesn't need to be delivered before you submitted your reserve matters. Do you remember that?
Sorry.
I put to you that your reserve matters could be submitted before the road is built.
It would have to be for the road.
Yeah.
I'm talking about the road now, Mr. Young.
Okay, but your first phase includes you said the houses that will be delivered in your years 1 to 5, phase 1 of housing.
Yes.
That's separate from your road. That's a separate phase.
No, again, it's not. They're overlapping phases.
Yeah.
So again, I think the important thing to look at if you go back to paragraph 310 and what I think would happen in practice is you get on with your road, if you like, you go through the approvals and everything else you need for that. You would then take a view about, actually, I think I'm going to get my approvals, I think I'm going to build a road in this timescales, if you like. Then you would, again, this is my just assumption, if you like, you would then sort of work back in terms of, well, the road's going to be delivered then. I want to make sure that by the time that road gets delivered, there's housing there and I've sold the plots and everything else. So you try and time the kind of delivery of the homes. So there's some homes there, potentially the same sort of time as the road opens.
Yeah. Let's go back a couple of...
The important thing is it's the overlapping. This isn't a sequential process. Clearly you're going to get on the road in the initial stages, but I think that's what this phasing is representing. There's a sort of shifting of the kind of the way it works.
I have to admit, I was more ambitious for you than that. I thought your phase 1 housing reflected the fact that phase 1 incorporated, a bit like the appeal I was at last week, where phase 1 incorporated the first phase of housing, but also the entirety of the road.
It may well do, but again, it depends on how you do that.
Yeah, you're not going to submit a reserve matter for half the road, are you?
Again, I haven't thought about it. I haven't given that any thought.
There's something in the Section 106 or conditions that the road is a single phase for both developments.
Yeah.
Whether it includes houses, I don't know.
Yes.
That's a good point, madam. Yeah, I've just taken it at face value at your 310. Phase 1 housing. Either the road is an earlier phase. Sometimes they're
It
called
could be
phase.
a parallel phase. That's the
Yeah.
important point. That's what I'm
Sometimes
saying.
we call it phase 0. You've got to get the road in, and then you've got the phasing of the houses, or whatever it is. But what you're saying in years 1 to 5, phase 1 housing, the 250 houses, and my point to you is because it's triggered at occupation, then you can submit your reserve matters. You obviously, as you say, have to for the road, but also for the houses. The delivery of the road doesn't need to inhibit the submission of the reserve matters for those houses, does it?
Correct.
Yeah.
You can't, fundamentally, you'd be pretty foolhardy to sort of not have timed the kind of the approvals process and in effect how long it takes to build and everything else. So you've got this disconnect between the kind of effectively when you wouldn't have houses there just sat there until the roads are occupied, because that's just I would have thought from a practical kind of commercial perspective. It's just dead money effectively. You've got something that you can't sell.
So we've got this, if you can't acquire it by agreement, then we've got this situation where we go down a CPO. There'll obviously need to be negotiations, you'll know that.
If there's a CPO, that's an important point.
So that was what I've just said to you. Did you not understand the question?
Could you answer the question again? We said,
yeah, so I said, if it can't be acquired by agreement. What that means, Mr. Bashford, is that if you can't agree it, then there isn't agreement between the landowners, yeah?
More of that, yeah.
Okay, so if you can't agree it and it goes down the CPO route, what sort of timescale have you factored in there?
Again, I've not been involved with delivery timescales.
Oh, okay, all right. So, all right, that's very helpful. So,
but critically, as I say, from experience elsewhere, I don't think there's anything stopping you getting the approvals in parallel with that process. Just from my experience of doing city centre schemes, we have gone on and got on with the planning process, and then the kind of CPO process has gone on in parallel. So parallel, it's not a sequential process.
Yeah, I think we're in complete agreement, because I think your clients are safe in terms of needing to ensure that the planning permission is implemented in some way by January 2023, broadly.
Do you mean 33? Sorry.
Sorry, 33, yeah, you're quite right. To 33.
As a backstop,
yeah. So if the CPO process takes a long time, then, we can see that they'll be safe. They're not going to run out of time with their planning permission or lose the planning permission or be unable to implement it until about, what would that be? That's about 7 years away.
Start the road, couldn't you? I mean, it's the sort of the left-hand side of the road that that northern western bit.
Right.
So there's no reason why they couldn't, as long as they were confident that they were going to sort out the problems. You could start.
Absolutely. And if you're totally confident you're going to win a CPO, and let's be honest, a lot of them are successful, but not all of them, then that's fine. But you'd obviously want to know. I mean, the thing about the CPO process is obviously if Kent County Council did that, and as Mr. Pereira I think made the point, why would a highway authority that wanted to deliver a road in the context of its local transport plan not go ahead with the CPO? Well, subject to what the members think, one can see the logic of that. But what's also included in Section 106 is, of course, your clients or whoever acquires the site, your clients will have to financially back the cost of the CPO and the acquisition of the land, won't they?
Again, this is questions about compulsory acquisition, which I think we're at a planning inquiry. Just looking at it realistically, if the land can't be acquired and there's no evidence that it can, there's no evidence that it has attempts have been made to do so. There's no evidence it can't either.
No. But I haven't seen any evidence that says yes, we're in discussions and we're close to acquisition and so on. But if that's the case, then realistically, there's no houses going to be delivered off this site for the next 5 years, is there?
I think that's just speculation.
Okay, all right. When do you say then? When do you say that the Secretary of State should work on the assumption that there would be delivery from this site?
Well, I've showed you that table earlier, so.
Just tell me when will the first completions on your evidence be?
Illustratively, nothing to do with land ownership, but from a planning and kind of mainly relating to the consenting and process and just experience. That's what I showed earlier. So. 2029, I think it was on that.
2029. Okay, all right.
First occupation.
Yes, and that's what it delivered. Yeah.
Okay. Now, do you think the timing of that delivery, in a case where you pray and aid 5-year land supply, do you think that is relevant?
Sorry, just to say, we are not praying an aid 5-year housing
Okay.
supply.
Yeah. So.
And that's been through the evidence the last couple of days of the inquiry.
Yeah, because you're not planning to say anything about the state of the council's 5-year land supply.
No, we are saying things about the 5-year housing land supply.
I think you
In terms of
probably are.
It
Yeah.
engages the tilted balance.
Yeah.
But what I'm saying is that we recognise this is a strategic site, and it may help with the 5-year housing land supply in the later stages, year 4, year 5, as we've just shown you on that table.
Yeah.
It's a strategic site. It's going to address strategic issues. It's a long-term plan.
Yeah, nobody doubts that. Nobody doubts, even with the northern site, that this is a longer-term ambition. There's nothing wrong, is there, Mr. Bashford, with delivering houses outside of the 5-year period, particularly in the absence of a local plan, is there?
Right.
Yeah, but it's important to know there's going to be a contribution in the 5 years. Your case is, well, there will be. Because
well, I'm saying there can be.
Oh, right.
Again, I've been very careful in the wording of my evidence, and
Okay.
others have as well. So, yes.
You can understand why my clients would be keen to see the road delivered, can't you?
I can, yes, of course.
Yeah.
It's someone's paying for the things in their plans, of course.
Yeah, and they want to see it delivered if it's in a local transport plan, and your clients are the only show in town, as has been suggested. Yeah.
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 Well,
Good. Okay. You did say, yeah. There's, sometimes it's literally, but only show in town has been a bit.
at the moment, yes, correct.
Yeah, good. I don't think there's a huge amount between us here. What I think we're talking about is the realism. I read with interest the paper that my learned friend put in from James Scott.
Yes, I don't know if you've seen the social media thing, but it was. I was there, and it was certainly an experience seeing a rap at.
You saw it
on a Sunday morning.
You saw it. You saw it live. Yes.
I did see it live.
Do you remember his preliminary comment about KCs?
Yes.
Yeah, he said he was surprised that any KCs would know who the Fresh Prince of Bel-Air is. Yeah. Those who are young silks, and by that I include my learned friend, would know exactly who the Fresh Prince is. Yeah. Not all silks are 65. Some are just in their 40s. So yeah, well, I saw it's very a very entertaining sketch by Mr. Scott. If you take up his paper, please, which has been put in, and go to page 19.
It is 170. I think is it 174. Sorry, 100.74.
This is a helpful discussion. Maybe you'll tell me if it's not. I'm still on the northern side. We are going to go past 11 o'clock. Yeah, because we've got to talk about the southern side. But if you're happy for me to,
Let's carry on.
Okay, thank you very much. So, at the top of the page.
Sorry, page 14, hard copy.
No, 19 hard copy. It begins with it's a box where he's put the difference between prophetic consent outcomes and flexible consent outcomes.
Correct.
And what he's saying for super strategic sites, as he calls them,
Yes.
that James has been involved in, super strategic sites, what's better is a flexible consent. That's his approach. And at trust, it says, build trust through honest conversations and ongoing engagement in decision making. Do you see that?
I do, yeah.
So trust is, for a big site like this, trust is a really important consideration, isn't it? You'd agree with that?
In general terms, yes. And again, this is a holistic thing about promoting the sites as well. So, yeah.
What we want to know is that, what developers say they're going to do, they are going to do. And on these bigger sites, that's really important.
Yes, and that's why we have Section 106 agreements as well. So, again, just comparing and contrasting perhaps with the Chilmington Section 106, if you like, there's an awful lot of scrutiny on this with the experience of that. So you would expect there to make sure that things are not just the kind of general trust, which is important, but actually making sure that's codified as well. So.
Yeah. Now, you'll know enough about Section 106s as a planner to know that after 5 years you can apply to amend them, can't you?
Yes.
Yeah. You can do it before that, in fact, with consent from the local authority.
Correct, yes.
Developers are ingenious, though. You probably know that. And the latest thing they do is they submit a Section 73 application to amend the conditions, and then say the Section 106, because Section 73 creates a new planning application, doesn't it?
It creates an additional planning permission, yes.
Yeah, and as a consequence of which it's been argued, and I'm not going to say whether I think this is lawful or not, because I only think it's got as far as an inspector's decision, but they will argue, developers, that the Section 106, even though you haven't reached the 5th year anniversary, through a Section 73 can be reconsidered through that Section 73 application. Are you aware of that?
In general terms, yes, you're creating a new planning permission, so you must be therefore creating a new Section 106 agreement.
Is that the case, though, if you have a clause in the original Section 106 to preclude that?
Yeah,
I think you can, can't you?
You can have that clause. I don't know whether the examples that inspectors have accepted, where they've accepted this route, involve Section 106 that include that clause.
Right, I see.
I personally, for what it's worth, think it's seeking to undermine the effect of Section 106 by seeking to go around that. But you're aware that as I understand it, with all the difficulties with the London housing market at the moment, people are looking at ways. People are looking at ways to revisit viability that doesn't involve not examining the Section 106 for 5 years. You'll be familiar with that.
I'm broadly aware of that. Yes.
Yeah. And then under the new legislation, the LURA, there is a new provision, Section 73B. Are you aware of that?
Broadly, but remind me.
Yeah, what it says is certainly intended to be a broader provision that the planning permission can be amended under Section 73B unless it creates a significantly different planning permission. So I would respectfully suggest to you that's broadening, and certainly that's the intention of the legislation, to broaden the opportunities for developers to revisit the development. Yes.
Just to be clear, I'm sure this is all understood, but those provisions aren't in force. And as far as I'm aware, there's no that the new LURA provisions aren't in force, and there's no indication from this government as to if and when they will be brought into force.
No, you're right. They're not in force.
I'm just saying, sort of almost just for people watching, if you like.
Yeah, that's a perfectly fair point.
Sorry, just for my own interest. So Section 73B then.
Yes.
Can that, but that can amend a planning permission, but can it also amend, if the planning permission is subject to a legal agreement, what's the relationship of that? And also, what's the situation with considering it under, I can never think of it's not Wheatcroft anymore, that basically you can't change the nature of the application.
Yes.
Or permission, rather.
Section 73B,
yeah,
not yet implemented, is clearly seeking to widen the scope of the existing Section 73, make it more flexible in terms of the planning permission, and that doesn't itself specifically engage with Section 106A.
So what's that mean?
In terms of amending and B.
So that would still stand then, would it?
That would still stand. However, under the current Section 73, some developers are already seeking to revisit,
I understand.
and then we don't know, would that wider wording in Section 73B actually make it easier to facilitate amendments to the Section 106 through that route?
Yeah, and you said that there have been appeal decisions, did you?
There's been an appeal decision where an inspector has, and I don't think it's the only one, but I'm certainly aware of one where inspector has accepted that. Now, the reason I just ask you about this is your clients want a planning permission, and presumably, I don't know, but in terms of submitting this paper, your clients are after, for a super strategic site like this, a flexible consent rather than a prophetic consent. Is that right?
Yes, and part of the reason for submitting this was it has lots of resonance with the same way. So it's got the tier 2, tier 3 approach that's in this application, and it sets out the framework that's in here as well. So I think the key thing about this is, there's a balance in terms of, and we've heard it on others, in terms of whether we should have submitted a detailed design for the roads and everything else. There needs to be a balance, if you like, because what we're trying to do is avoid as much as we can having to, have to revise the application over and over again if we can, out of the permission if it's granted. And it's that balance, because you need to have enough certainty for it to be assessed in terms of environmental statements and basic Rochdale envelope principles. But then things will evolve over a 20-year time period. Again, one of the things in this paper is talks about policy of sort of continually being tinkered with. Talks about economic cycles. Things do change, and I've been involved with a lot of big master plan permissions, and there are amendments, but it's getting that balance right, of getting the framework right, getting the principles established, and allowing a flexibility for things to evolve. But fundamentally, at the point of granting planning permission, though, again, I think this discussion about 106A and 106B came up earlier in the inquiry. We're not pondering what's going to change because we don't know at the moment. What we're trying to get is the balance right in terms of what we do understand, and then try and codify that and make sure things are delivered in the right way in the 106 and the planning permission.
Yeah, and this comes back to the trust issue, really, about being able to trust what is being said. If you go back a page, so page 18, in the same pathetic versus flexible outcomes, you can see the issue of viability, yes? I'm not going to revisit the relevance of viability.
Yes, and that's effectively what there will be, and again, my understanding of the 106 is there will be review mechanisms at phases.
I haven't asked you a question yet, so if we just go at one stage at a time. So if you just find the viability section, page 18.
So do you mean viability on the table?
Yeah.
Okay.
Do you have that, madam? Okay, and under the flexible consent outcome, viable consents maintained through adaptable reviews based on large-scale economics. Now, as you rightly point out, over development that might take 30 years to develop, there'll be economic cycles, there'll be all kinds of things. Nobody can predict the future, not that well. So, review mechanisms can be useful, yes?
Yes, here again. So I didn't say, you said 30 years. I didn't say 30 years, but
Mr. Simons the other day talked about the timescales for the proposals. It extended into 30 years.
Oh.
It doesn't matter. I don't think much will hang on it. Okay.
But yes, there's upward only reviews in 106, as I understand.
Well, that's my point, isn't it? It's only upward reviews. So if you reach sunnier climates, if you like, and there's more money available, or circumstances change, or bill costs come down, then the affordable housing increases, yes?
Correct.
There's no mechanism for reducing it.
Not as I understand, no.
No, but in 5 years' time, or if not before, then it would be perfectly possible to revisit those issues, yes?
That's speculation at the moment. We have a position
It's
at the
not
moment.
speculation, it's a matter of fact. You can revisit those issues in 5 years' time, yes or no?
Yes, technically you can revisit them.
Yeah.
Key points that we've got at the moment is, again, we've got to take a decision on this. The inspector informing the Secretary of State has to take a decision on the evidence in front of us at the moment. That evidence has been the viability assessment that's been agreed with Swale and the applicant. That shows what the maximum reasonable amount of affordable housing that can be delivered at the moment. That's how you take decisions. You don't speculate about, what if, things will evolve, but we can't speculate what they'll be at the moment.
Yes, and what the provision in the latest viability evidence from Mr. Ord said, which
Sorry, I don't know.
So Mr. Ord was the council's viability, Mr. Orsts was the viability expert for Swale, yes?
Yes.
Okay, and he made clear that his appraisal was not based on any of the strategic road infrastructure costs assessments other than the information provided by the appellant.
Again, I wasn't there at those sessions, so I can't really comment.
Yeah, it came with that health warning. And I understand the dialogue that's been had over that issue, but the position is that as far as the northern site is concerned, if my client's evidence is preferred by the inspector and by the Secretary of State on the northern site, then the scheme is unviable. Are you aware of that?
That's your hypothesis, yes.
Yeah, well, it's the evidence, and if that's what the evidence shows.
The word if, but yes, but that...
Yes, of course it's if. That's what I said. If our evidence was accepted, your scheme is unviable. Are you aware of that?
Well,
it's not that hard to accept. I'm not saying your evidence has been rejected. What I'm saying is if our evidence has been accepted, your northern scheme is unviable, isn't it?
I can't comment on that.
Well, I think you probably can. Do you know what that evidence shows?
I know there's a disagreement about costs. So, again, that must play into viability, but
your
what the consequence of that is, so.
Your evidence doesn't contemplate an outcome in which our viability evidence has been preferred, does it?
I don't know. I don't know how that goes to the planning merits, though.
I just ask you, does your evidence contemplate a scenario where the northern scheme is unviable?
I don't know. I wasn't there at those sessions. I can't answer.
Yeah, it doesn't. Your evidence. Yeah, your evidence is it's not relevant at all, isn't it?
Right.
Yeah, the viability, and so we're in a situation where your clients secure a planning permission. It's unviable on our evidence.
On your evidence, yes. But again, I believe we've got. Again, I presume we've got contrary evidence as well. So
you have, yeah, and I've not. That's why I've said if, but if I'm not being clear, I'll say if really loudly.
Yes.
Okay, if our evidence is accepted, are you with me?
Big if, yes.
Yeah. If that's why I said it loudly.
Yeah.
Okay. If our evidence is accepted and your scheme is unviable, what's the answer?
The answer to what, sorry?
The answer to how any of this gets delivered.
Well, nothing to do with the planning outcome, if you like. So, again, we've had this discussion over the last few days. This isn't a relevant consideration.
Okay, so the delivery of the site, and I've seen the exchanges with Mr. Pereira, who's helpfully gone through it. I won't be able to better that. He has made clear and looked at the Wimbledon case, and it'll be a matter for submissions. We don't need to rehearse that.
So again, looking at the Wimbledon framework, I can't do anything with this. So from a planning perspective,
yeah,
so,
okay.
Again, you've had other witnesses from viability and Ms. Dickinson as well that kind of answered these type of questions as well.
See, my client is interested not just in securing planning permissions. They're not going to sell it on or try and make money out of this. They're interested in outcomes. So they might be interested in the road being delivered. Do you understand that?
That's their perspective, but we can't take that into account in the planning balance. I understand the concerns, and they're legitimate concerns, I'm sure, and understand the context of them. But as a planner, can't do anything with them. Doesn't go to the planning merits. Yeah,
that again, I'm not trespassing on the debate between the council and yourselves on that, and we made that clear in the notes that were provided in response to Mr. Simons. Okay, we're not getting into the whole issue about the deliverability of the scheme. What I'm just looking at is...
I don't understand why you're asking me these questions.
Oh, I see. Okay, well, the reason I'm asking the questions is the Secretary of State might think it's important about whether your scheme has any prospect of being delivered.
Might be, but again, from my perspective as a planner, I don't think the Secretary of State can actually take that into account in the planning balance.
Okay.
It could be that it's Mr. Pereira's position, if you like, that they'd find it helpful to understand that, but I don't, and again, this has been agreed with Mr. Dygan as well, is that doesn't go to the merits of granting planning permission or not.
Yeah, it may be that you secure a planning permission and it just can't be delivered.
But again, that's speculation.
Yeah, absolutely.
It's not relevant.
And Mr. Pereira went through why that might be relevant when there isn't a local plan, when you're looking at other sites and so on. That isn't our case. I just want to deal with the reality of the delivery. Now, we suggested that your clients go and speak to Homes England about the funding gap. As I understand it, there were discussions about loans. Are you aware of that?
I believe it came up in discussions with Mr. Gearing, but that's all I'm aware of. So again, this is not really relating to planning matters. So
okay, and we also raised the issue about speaking to them about achieving that the possibility of of loans. But grants, you can apply to Homes England for grants. Do you know if your client's done anything about that?
Again, I'm not the witness to answer that.
Okay, all right. I understand your position on that. So we're in a position where we don't know about the acquisition of the land. We don't know about whether a CPO will be required. We don't know about the timescales of that. But both your clients and mine want to see the road delivered, yes?
But
Is that right? Do your clients want to see the road delivered?
I'm sure everyone would like to see it delivered, but I don't understand.
Just focus on the question. Do your clients want to see the road delivered?
I'm sure they'd like to see the road delivered,
Yeah.
yes. But I don't. What I'm trying to qualify that with, I didn't understand the first part of your proposition, so that's not relevant to planning.
That's your position.
Yes.
I think others would take the view that whether this site can be delivered and the impact that might have on permissions for other sites and what it might mean for the local plan and having this as an allocation of plan, others may think that's relevant, okay?
Yeah, that's your thesis, but I don't agree with it.
Well, it's for others to make that point. It's not a thesis, okay? You have, I think, been clear in your answers. You don't think delivery is a material consideration.
Correct.
Yeah, okay. That's your position. And the same with viability. Whether this scheme is viable or not, you think is irrelevant.
The scheme, again, I understand this was discussed with Mr Dickinson. The only thing we need to consider from a viability perspective is, again, this has been agreed with the council in terms of the viability, is have we delivered enough affordable housing?
Yeah, that's the only issue.
That's the only question we need to ask ourselves, and other obligations. So.
Yeah, your clients are, as I understand it, and you correct me if I'm wrong, resisting the commuted sums associated with the highway works, aren't they?
Again, I'm not aware what the details
Oh,
of
okay,
discussions on
okay.
106 are.
Because then we would have a dispute over a Section 106 contribution.
Right.
Okay, all right. I'm not going to take you through the PPG in relation to those issues. Other alternatives, if your site is unviable, it's been mooted that the developer might take less profit. The PPG talks about a profit margin. The landowners might accept less money. You don't deal with any of this, do you?
Sorry, this is completely out of my scope of evidence. And
Yeah,
we've had two witnesses earlier on this, so I can't answer any of these questions.
Yeah, you're not an expert on viability,
No.
and you don't give evidence or know about these issues, do you?
No, it's not my evidence. I'm a planner and not a viability expert or a surveyor.
Yeah, and that's, from my point of view, that's very helpful. You've just clarified that it's the evidence of the other two witnesses which we've heard from on your side, which is, forgive me, Mr Mitford Slade and Mr Gearing, yes?
But there's, just again, putting this back in the planning remit, I know there's been an awful lot of evidence on all of this stuff. I'm not sure a lot of it's actually that relevant. There's lots of toing and froing between this stuff, but so what, if you like? And again, that's been agreed with the council, is actually this isn't a Section 38(6) planning balance issue.
Yeah, I understand what your position is on this, and your position is if it is unviable, that doesn't matter. The Secretary of State shouldn't take into account.
Not my area of expertise in terms of...
Oh, I see. So not that it's not relevant, just that it's outside your area of expertise.
Well, it's not relevant to the planning balance, and it's outside my area of expertise.
Okay, well, I understand your case. That is 11 o'clock. That is the end of the northern side. So, Madam, if that's an appropriate moment.
Yes, it's just you sort of dangled this bit of fruit, which I can't let go without asking you where it came from. This appeal decision you were talking about
Yes.
reconsidering the Section 106, I think.
Yes.
Could you just give me the reference number, please?
I'll find it. What I know is that Tom Hill was the advocate who acted in it. So that's the bits the barristers always look for, who did the case for the appellant. But I will find it.
Do you mind?
Somebody was asking me questions about it last week.
I mean, it's interesting. Not necessarily, I don't know whether it's relevant at all here, but it's interesting for other things.
There is if you're interested, be careful what you wish for. There is a High Court case as well from 2020, which was called Norfolk Homes, and it was about the debate about there was a Section 73 consent in that case. And there was a debate about whether or not the original 106 continued on the drafting of that 106 continued to bite or not.
I think that's a slightly different thing, though, isn't it?
It is different
because I think that's pretty well established, isn't it? That it doesn't, or at least because you're granting a separate planning permission.
That's right. That was yes.
And that's why I was talking about the clause. You could have a clause. You can have a clause in Section 106 that anything subsequent under Section 73 will be bound by the. But that, I think that's slightly different to this other thing you were talking about.
Pains to point out, I don't think that's high court authority. I don't think It's High Court authority to support what the inspector has done, but that simply means it hasn't been challenged.
Outside the challenge period, then.
I think so. Yeah, I think it was last year. Yeah, but I will.
I would be interested just to read it. Thank you.
And you just want the appeal reference number?
Yeah, I'll do.
Yeah. Okay.
Thank you very much.
Mum, can I just say something?
Yes.
Yesterday and this morning, Mr. Bashforth has in various ways said what the council's position is on this matter, and I just want to make it clear what the council's position is on this matter so that everyone knows. It's correct, as Mr. Simons and Mr. Dygan agreed, that this question of viability stroke deliverability doesn't feature in our planning balance, and the reason it doesn't feature in our planning balance is because the council doesn't challenge the viability and the delivery. That's the output of the viability assessment. But it's also correct that it's an issue that's been put before the Secretary of State. And it's also correct that the Council makes a request formally that it is therefore addressed. And the reason why we ask it to be addressed is because of the impact that lack of delivery or doubt or uncertainty over delivery would have on the proper planning of the area and the plan making process, as explained by Mr. Dygan and put to me in cross-examination. So that is the way we put our case, and I hope that's clear, and therefore people can make submissions on it. But I wanted to make it clear because it's being characterised in various different ways. So that's how it is. Thank you.
I think I did understand that, but thank you for clarifying.
Just on that, that's very helpful. Just on that, I did see the exchange with Melinda Friend and Mr. Dygan. I think I certainly saw about looking at the call-in letter and the issues that were raised by the Secretary of State. But obviously, we looked at that some time ago, but it includes obviously any other issues that you think are important. You don't need me to tell you that. And obviously, when you've heard evidence on things, unless you think they're wholly irrelevant, then I don't think there's a need to refer back to the Secretary of State and ask whether other issues are relevant, because it's left entirely at your discretion, isn't it?
Absolutely. I mean, I've had days of viability. Couldn't just, well, tempting that might be. I don't think I could just set it aside and just say, well, I'm not going to deal with that. So, yes, have no fear. It will be properly dealt with. What the Secretary of State does with it is obviously up to him. Right, okay, let's have a break then. 20 minutes till 10 past, half past, thank you, half past 11. Right, it's just now 11:30, so it's time for the inquiry to resume. Sorry to go back to that point about the Section 73 again. But it is quite important to some extent, because I realise after 5 years you can apply to change Section 106, but traditionally not within the 5 years, and then this thing comes up. But if you have the Section 106 contains the clause about applying to subsequent Section 73 applications, then surely you couldn't just come along and have another.
That's right. One of the reasons.
Agreements. I
mean, if you want, as I said, I appreciate what you said about the case I mentioned being a different point, which it is. But one of the things it demonstrates is how much this question is pinned to whether or not there's a clause like that in the 106. The drafting of the 106 is all important, because the 106 tells you what it applies to. So I agree with you, but also just to say that we will be saying, I think, in our closings on this general question about 106, 106A, Section 73, Section 73B, well, not enforced, but all of this, that the Secretary of State would have to be really careful about relying on the potential for future decision-making exercises, either by Swale or by him or by another inspector, where, be it a 106A or be it a Section 73 or be it a 96A or anything, because any of those are their future public law decisions that will be taken by future decision makers, about which this inquiry can only really speculate. So I agree with what you've just said, and the 106 can tie itself to future Section 73s. But even if it couldn't, I think we would be saying that the potential for future changes are to be judged on the merits of those changes at the time, whatever they are, whatever they may be, whenever they come forward, if they ever come forward. I think the sort of legal orthodoxy that what we're going to be suggesting is the legal orthodoxy from a public law point of view is that we've got to judge this scheme on what it has in it, what it's got in it, how the balance sits one way or the other, approve it or refuse it, but it's got to be judged on its own. It can't be judged with reference to the potential for it to change in the future.
Well, I do realise that. I mean, as far as I understand, this is all a bit of a thing that's sort of gone under the wire, really, isn't it? But, the intention was that for the reasons of certainty, which is surely a consideration of some importance, that if you sign up to a Section 106, it remains valid for 5 years and then you can reconsider, because obviously circumstances can change and all the rest of it. But Section 73 comes along and, obviously you create another planning permission. And then, of course, there's the knotty problem of, well, is it tied to the same legal requirements of the Section 106. But the Section 73 relates to conditions.
Absolutely.
It's not meant to it's never meant to relate, although it does create a new planning permission. It's not meant to sort of change the nature of or the type of proposal sort of before. And I think it sort of got a bit over. Not lawyered, perhaps that's the wrong word, but people looking for sort of ways of reducing the certainty of things. And so whilst I understand what you're saying,
of course,
I can also see the other side, that people want to know where they stand, at least for in the shorter time period.
It would assist. So I agree with the legal orthodoxy. You can't write a decision that says, well, on the basis that this may change, but I would say that adds to the importance of understanding the viability evidence. But can I just give you that appeal decision, if I may? So, inspector's name first, Graham Chamberlain.
All right, okay.
Number is 333.
Yeah.
222.
Yeah.
5.
Oh, right. Yeah.
29th, I think, of March last year.
Yeah.
It was suitably named Mayday Road.
Was it for a big scheme, or was it just for sort of a couple of houses?
No, well, it wasn't a couple of houses. I can't now tell you that in front of me about the exact size, but what I do know is that they sought an amendment of the condition,
Yeah.
but then use that to revisit the viability.
Oh, right, okay. Oh, well, or we could all
It was
read it.
for,
Yeah.
it was for, it was
57
in
new
Croydon.
dwellings, 57 replacements, 3 replacement buildings, I found it,
You found it.
comprising 57 new dwellings and associated access. And what Inspector Chamberlain was considering was condition 2.
Is that a viability review or something then?
No, it was plans, but what
right.
the developers have been doing is amending one plan
Yeah.
and then saying, well, it's a new permission, you need to revisit the whole thing, including all the viability. But I'll let you read it for what
Yeah.
it says. And it's a short decision, but Mr. Hill, Tom Hill, was there for the appellant.
Obviously did a good job then.
The council's, I think, looks like the council's in-house solicitor acted for Croydon.
Rightio.
And I noticed that, Turner Moram, who are viability experts, were appearing on behalf of the appellant.
But was there any clause in the original section 106 about a section, 73
That is a good
application?
question.
That I don't know, but
No.
I can certainly find out because, like my little friend, I'm sure I know people who are involved in that case.
It's an interesting one. Yeah, one of the big debates, as Mr. Young says, from the council there, it was in Croydon, I think, was whether or not Section 73 could be used as to achieve, among other things, a reduction of affordable housing, I think to 0. And what they sought to do, it would seem, just scanning it through now, was to submit a unilateral undertake. Is that what you've just said? Sorry, I don't mean to duplicate what you've just said. You submit a UU, and they were saying grant the Section 73 subject to this new UU, which otherwise says all the same things as the old 106, and the new Section 73 will be subject to this UU. Council was saying that shouldn't be done under Section 73. The inspector, obviously, as Mr. Young says, went along with the developer, which is interesting, and he said there was no need for an application under 106A in those circumstances. Quite a short decision; it's only a few pages.
But I mean, it might have, if there was no clause in the section 106, then
Yeah.
it wouldn't have
No,
been, sort of carried forward to the new permission, would
yeah,
it?
that's right.
So, it's important to know that.
I'm not sure the inspector. He doesn't. I don't think he refers to any such clause, if you like. So we'd need to have a look.
Right, yeah.
The original permission was granted in. The original permission was granted in March 2022, and what caught my eye was that was less than the 5-year period. So although there are legislative provisions, it's got Supreme Court
They
written
wanted
all
to do
over
it
it.
quickly. Yeah.
Yeah, it's got. They acted before the 5-year period,
Yes.
so it's in conflict with the legislation, but the inspector decided on that basis. It doesn't look. I don't think it's been challenged, but we can double check that. I think we would have seen it. I'm sure. Yeah.
Well, you wouldn't be able to challenge it now, but
Yeah,
I'm
there
presuming it
are
wasn't.
cases that still haven't got permission, even though they were issued 5 months ago. At the moment, there's a real backlog in the planning court. But
Oh, I see what you mean. You mean it might have been challenged, but
it could have been. Yeah, there are cases just sitting there at the moment because there's for a variety of reasons. Anyway, long story short, we will try and find out if there is such a clause. But it's clear that it was a Section 73 application submitted and determined before the 5th anniversary of the planning permission.
Well, yeah. But I think whether the presence of that clause is a relevant factor that might have made the difference, if you see what I mean.
Yes. Presumably, from what Linford's saying, the Section 106, both Section 106s in this case have that clause.
I'd need to check. I'd need to check. The town legal team will tell me, but they're not here.
And what would
but
be-
we'll come back to
Despite your point about flexibility,
Yeah.
you think they have. Well, we need to know. Obviously,
yeah.
But what I think would also be helpful, if I may say so, is if... I just wait some friends.
Sorry, I'm just getting instructions. We have got a clause that says, I'm paraphrasing,
have to
will
wait
apply
5
to
years.
future, will apply to future Section 73 applications or words to that
Yes,
effect.
yeah,
So it does
yeah.
have the clause that you're talking
yeah.
about.
But that doesn't. But after 5 years, you can of course apply
Well,
for the.
Yeah,
the
I
whole
mean
thing, can't you?
that is true, but that then comes up against what
That's
I've
a different
described.
thing.
I mean
That's a
that
different
could
thing.
always happen, obviously,
Yes,
and it is happening in London and it's happening elsewhere because
No,
build costs
appreciate that
change.
You couldn't stifle that.
Exactly.
What
No,
I'm
you
talking
can't.
about is at least having 5 years of certainty.
Yeah. Yeah.
Everything else.
Yeah. Understood.
Exactly that. Yeah, yeah. Well, it may be useful if town legal provide a note on that actually about the efficacy of the clause.
Okay,
Well, I mean,
thank
that'll
you.
come up
Something to-
obviously at the 106 session.
Interesting point. Right, thank you very much. Sorry, Mr Young.
Every day's a school day.
Right, yes.
Ms. Blattery, we're going to move to the southern site now. Okay. Now, your clients are proposing a master developer role.
That's my instructions, yeah.
Yes, with or without rap music.
Yes.
Just so we're clear, there may have been some doubt in Mullin and Friends' mind, but I don't think there is now. We have never questioned the master developer role, have we?
Again, I don't know. I haven't been involved with all those discussions.
all right.
That's part of the inquiry.
Let me just help you with that. We haven't.
Okay.
And in particular, because Mr. Spilsbury is involved in various schemes that involve that, but that's a matter of record. Now, let's be clear about this. This is a ambitious proposal for the entire delivery of a new motorway junction and a 6-kilometre link road before a single house is occupied. It's an ambitious proposal, isn't it?
It's certainly a strategic scale proposal, yes.
Can you think of any other proposal in this country that's come forward where the developer has forward funded a motorway junction and a similar length of road before a single house is occupied?
I'm not aware, but my experience isn't necessarily the be-all and end-all.
No, it's quite broad, but it's not. Doesn't have to be definitive. No, I'm just asking if you know that. I'm aware of.
I don't know, Mr. Young.
Yeah. Again, you've recognised, haven't you, on the basis of the agreement between my clients and your clients in terms of highway matters, it is part of that agreement that the road is delivered before a single house is occupied on the southern side.
Correct.
Yeah, and again, we can recognise that is a very important component of the agreement, isn't it?
It's important for the sequencing of development, yes.
Yeah, it's a very important part of your client's proposal to not have occupation until the entire road is built.
It's a key element of the 106, yes.
Key element, yeah. Okay, good. All right, and your clients have recognised the importance of ensuring that if they start building this road in the motorway junction, that it is complete, and that's what the bond is for.
Is that the bond for it's only on the south is the bond? I wasn't, again, I'm not close to the 106 draft.
Yeah, there is a bond for the south, and obviously that's the one with the very substantial sum of money that needs to be in a bond, but your clients have committed to that. That's part of the Section 106, isn't it?
I've heard mention of a bond, but not looked at the drafting, so that does sound familiar. So.
Yeah, so that's perfectly fair. I'm not here to cross-examine you on the Section 106 as a separate session on that, just your broad understanding. But in terms of looking at the scheme and thinking about, granting planning permission and will it be delivered, this is going to be a major part of housing delivery in Swale over several decades, isn't it?
It's part of housing delivery, but also delivering other things as well in terms of congestion and the things in the wider area, yes.
Yeah, I'm not taking away from the benefits, and nor am I getting into the benefits, frankly, other than recognising the highway benefits, which my clients are obviously interested in. But we can see that, the amount of housing that's proposed on the southern side, over 7,000 houses, is going to be a major component of development in Swale over several decades.
If it's granted, yes.
Yeah, okay. And as a consequence of which, the importance of ensuring the infrastructure is delivered, and by that I don't just mean the road, I mean, as well as the road, the schools,
yes.
Primary schools and secondary schools are fundamental to your clients' whole proposals, aren't they?
Yes, they effectively serve the needs of the new residents and others. So.
Yeah, because part of your case on sustainability, which we have accepted, we've not opposed, part of your case on traffic movements has been, this is about creating communities which are, sustainable, and where a lot of day-to-day activity, primary schools and secondary schools in particular, is internalised, yes?
Right.
Yeah, and that helps support the sustainability case, doesn't it? If you can say you're big enough to have a secondary school And the threshold for that is often around 5,000 homes. But if you're big enough to have a secondary school, you're not exporting your secondary school pupils out of your settlement each day. They're staying in the community, aren't they?
It's a general proposition, although parents can choose, but yes, that's the idea.
Yeah, you're right. We're in grammar school territory here, and I understand that. But there's parental choice generally. Yes. Okay, and lots of things come from that because, you know, schools aren't just schools. They can be places where people play football in the evening or other sports in the evening where activities take place. So a secondary school, as well as primary schools, can be a real focus for the day-to-day activities of people's lives, yes?
In part, yes.
Yeah. You know what I mean, don't you? When you get a new school and you get, you know, AstroTurf usually now, and you get floodlighting, you know, local sports teams, football teams, rugby teams, netball teams, they can all use these new facilities, and that's often part and parcel of what comes forward, isn't it?
It is, albeit there are some separate ones as part of these proposals.
Yeah. But what that does is help build community cohesion because as well as providing conventional, you know, community facilities and shops, often sports clubs and other activity groups are ways in which communities are cohesive, yes?
It's all part and parcel, yes, I agree.
Yeah.
We've all stood on a touchline watching football or rugby on a Sunday, yes, and when it's raining, and yes, of course.
Yes, or participated.
Yes.
Yeah. And so you would recognise that the schools are an absolutely fundamental component of your client's proposals. That's fair, isn't it?
It's a very important part, yes.
Just with my words, though, absolutely fundamental component.
It's semantics, but yes,
Good. Okay. I don't think there's anything to disagree with. Okay. Good. Right. Now, my clients have obviously looked at the viability of providing the roads, and we're at different positions on that. But if we're right, okay, and there isn't enough money in this development to pay for the roads, the first thing that there's a number of options, okay, to ensure that delivery still takes place. Your clients would be free, with or without the support of KCC, to apply to Homes England for grants, wouldn't they? They'd be free to do that.
I don't know the practicalities of
Okay, that happens on large sites, okay, I can tell you.
that, but yes.
Yeah, okay.
Practicalities.
But there's no inhibition here. There's no reason why they couldn't apply, could they?
No, they could go and get funding themselves, all
Yeah.
sorts of things they could do.
Yeah, indeed, your clients have been to my clients, specifically, Mr. Birchall gave evidence, and he mentioned this. Your clients have been on other sites and discussed funding for things that have been brought forward by Quinn. That's right, isn't it?
I'm not aware.
Okay, all right. Mr. Birchall mentioned that. But, okay, that's one route. Another route is that affordable housing can be reduced. So there's a significant amount of affordable housing on the southern site, isn't there?
There is, yeah.
Yeah. And for 5 years, although subject to what Section 73 and 73B might allow if that's enacted, etc., but subject to that, affordable housing is an area where if there isn't enough money to pay for the road, which is necessary before anything else happens, affordable housing could be reduced to help the funding gap, couldn't it?
It could. Could I just sort of, again, this is all sort of speculation in a way. I think the important thing is that it's not just about it's not sort of a sort of balloon, if you like. It's just not just a case of the Section 106 pot changing. I presume, again, this is my high-level understanding of how viability will work, but presumably the developer also, as well as looking at funding, that might be its own funding, it may be Homes England or everything else, and also take a view on the profit they could take as well. So it's not just a case of...
I haven't come to those yet.
Yes, but I'm saying it's a general, just as a kind of just putting this in a bit more context, if you like.
Yeah.
It's not just a case of, well, this could go down, that could go down. What I'm trying to apply is there's lots of other things that could happen as well. It's not just the 106 things. So.
Yeah, absolutely. And we're going to go through those, and then we'll be done for the morning. But
again, just on the point about... It goes back to the point about the Section 106 and orderly delivery as well, though, because there's two parts to that. One is there's what's in the Section 106 and the very clear triggers for those schools, if you like. So But also, going back to your point, from my experience, it's really important for that placemaking perspective and everything else, the applicant and the developer would want to bring those things forward because it is actually quite important for them to sell homes as well. So it's not something I would have thought they'd be really looking to, welch out on, and I'd be very surprised if the Kent as the Education Authority would let them do that as well. So it's something, it's codified in the planning permission, but it's also something that has to be delivered anyway. So both from a commercial perspective, is my understanding, placemaking, it's not something you can just say, well, the schools may not be delivered. I'm not sure about that.
Yeah, well, let's hope that is what happens. But let's have a look at what might happen if there isn't enough money because the road is more expensive than you think it is.
But
if you
again,
go to...
Sorry, just picking up on that point, though. If the road is more expensive, that's the first thing that gets delivered, so you'll know those things. Again, it goes back to your bond point. This isn't sort of a Chilmington position where halfway through there was a problem. Those issues, if they come up, the orderly developers, you'll get your road first, if you like, so you'll know if there's anything, and then...
Yes, but forgive me, I'm sure you know this, my clients' interests do not extend just to roads, they extend to schools as well. Okay?
That's the point you're making.
You're right, this scheme doesn't happen. The southern site, nothing happens unless that road is opened, unless the Section 106 is changed in some way. But as things stand, as Melinda Friend says, under the legal orthodoxy of what you're applying for, that road has to come first before all other things, doesn't it?
Right.
Without that road, there is no southern site. Good.
Yeah.
Okay.
So again, it goes back to the harms point. So the worst case is you wouldn't deliver the road, nothing else comes along. Or if you deliver the road and other things, but there's no houses to go with them, so you don't need the schools and everything else.
Yeah, so long as the Section 106 doesn't change and there's attempts to deliver some houses without that, but that isn't your case at the moment.
But I'm just dealing from a planning perspective, so that the ifs I can't really consider it.
No. So if we have a look at the paper by James Scott, because he does look at the ifs helpfully as a master developer.
Yeah. But he's a developer perspective. He's obviously talking about planning, but as he said in the introduction to that paper, he's looking at it from a broader church as a developer, a lawyer. I think he even says he was trained as a planning barrister at one point.
He did. He was David Elvin's pupil, but unfortunately wasn't taken on. Viability review, page 16.
Sorry, is this the hard?
He is a very nice man. I'll just want that clear. If he's watching.
Is this hard copy or something?
Yeah, page 16 in the hard copy.
Yes, in there.
Oh, okay. Is it my husky voice?
Sorry, is that better? Yes.
It's Mr. Bashford, is it? They can't
Yes.
hear? Okay. Speak up, Mr. Bashford.
I will do.
Okay. All right. Viability review.
Yeah.
Large-scale sites have upfront costs. Well, we know that. This is a classic case of that, isn't it? It's got big upfront costs.
I don't know. I've got any reference about it, I presume.
200, 300 million. It's quite a big upfront cost, isn't it?
But relative to everything else, I don't know. Hard for me to reference that.
All right.
So again, I'm not a surveyor, and yes, I mean it's.
You haven't sort of addressed your mind as to whether this site's got big upfront costs, have you?
Not from a planning perspective. Not my job to do that.
No, that they are established a new place rather than blending into an existing one. Equally, the risks associated with taking a large site through the planning system and delivering significant infrastructure requires a suitable return. And that's what he's talking about, that's the developer's return, yes?
Again, for viability experts, not me, but
yeah. Affordable housing has become a balancing factor in this equation. And it talks about the challenges. And that's right, isn't it? The first thing that sort of goes in when push comes to shove is the affordable housing.
In terms of what? Sorry, just explain that as a question.
So if there isn't enough money and there's an application to amend the Section 106 in 5 years' time, or if it's done somehow beforehand and so on, generally speaking, it will be the affordable housing that is lost.
on the proposition of if you can as well. So yes, I mean that's usually what's kind of the thing that balances things.
London housing delivery is virtually at a standstill at the moment, isn't it? Because of viability problems, and what people are doing through this Section 73 route and whatever is revisiting the viability. Yes,
I'm aware of that. Yeah.
People estimating that starts on site might be as low as 4,000 in a couple of years' time.
They are. But again, they're also looking at things. It's not just about Section 106. I'm sure they're looking at how they fund things, how they phase things, and everything else.
Absolutely. And when they got their planning permission, I'm sure they told the local councillors, we'll deliver 40% affordable housing. But, things change and people don't deliver what they say they're going to deliver, and they want that revisited, and that's just part of the planning process.
Yeah, I think it's slightly different in London, just again, because, we'd be aware of this. But in London, there's the fast track route, if you like, and a lot of people didn't go through that route. They went effectively agreed to the mayor's 35% to avoid the kind of sort of viability route, and now that was fine when interest rates and everything else was so much lower a few years ago. But that's what's being reviewed at the moment in terms of it's going to be a viability tested route. That's what the mayor's looking at. So.
That's what they signed up for, to avoid late viability reviews, which create difficulties if they're not expedited by local authorities and their reconsideration of them. That's right, isn't it? And the mayor.
It's part of the things, but yeah.
Okay. So, look, affordable housing. Now, my clients, don't have any particular interest in affordable housing delivery on this site. That isn't their concern. And I'd be outside of my client's remit if I started to worry about the affordable housing on the scheme. That's for others to raise. But it does become a concern and an interest if this starts to jeopardise the other infrastructure. And you'll know that a lot of the Section 106 contributions in respect of these proposals relate to county matters, don't they?
They do. But they're not housing. They're, as you say, schools, there's waste recycling and other things as well.
Yeah, I think the suggestion is around 16,000, 17,000 per plot on top of the road, which is about 50,000 per plot. But, without getting into the specifics, which has been others, we've got a lot of interest in these issues. So my clients would obviously want to know that there is enough money to fund the roads and to fund the schools and the other Section 1 contributions. Those would be very legitimate things for my client to be concerned about. Yes?
Yes, same point as we were making earlier. Not sure how that goes to the merits of the planning permission, though.
Yeah, because your position is it doesn't matter if those things can't be afforded. What matters is getting a planning permission.
But it's gone through a viability tested.
Well, that's the answer to my question. In answer to your point that you just made, none of this is relevant to planning.
No, it is. So let me answer the question. So I think, the point I'm making is it's very clear in terms of the way the national policy works in terms of looking at. I'm very happy to take up the MPPF if you like, but
by all means.
Let's look at that.
Yep.
So it's paragraph 35. So it should be for plans to do this, and then it's about should be for including the levels and types of affordable housing required, along with education, health, and transport and things. So yes, you can look at those things as part of the viability assessment, if you like, but that's primarily related to, we have that from a affordable housing perspective, and that has been undertaken, as I understand it. It's been agreed with Swale. Again, I can't answer the point you made earlier with the caveats about what you were saying. Is it Mr. Orst you were mentioning? Again, I wasn't there at that point, but my understanding, there is an agreed position on these things, including, and that must, I presume, include delivery of the education, health and transport elements.
Yeah, so education, health, transport, those are all issues which are county matters, yes? And they want to be certain that they're going to be delivered, yes?
Well, certainly delivered. It's been part of the consideration of the viability for effectively being used for the affordable housing purposes to actually, again...
Yeah, but the viability in this case has gone beyond that. We've been looking at it because the District Council didn't really participate in that exercise. I hope I characterised that fairly. What the county's been looking at is whether everything that is proposed in your Section 106 can be afforded, yes?
But that's a different... Again, my understanding of the way the viability work is, it's to see if you're delivering the appropriate amount of affordable housing, and that's been agreed, taking into account those things that are listed there.
Yeah, I'm so sorry. We've got an issue about a commuted sum, for the roads. That's in dispute. It's a Section 106 issue that's in dispute.
So I'm not aware of that. So.
Okay. But in any event, regardless of the affordable housing position, my clients have been looking about whether their contributions and whether the road can be afforded, and the viability work on both sides, Mr. Mitford Slade as well, inputted the relevant figures, yes?
Again, I'm not aware of the details.
Okay, all right. Well, that doesn't matter. It can be a matter for submission. So the affordable housing could be reduced, but your Section 106 is an upward-only review, so certainly for 5 years, subject to Section 73, that can't be revisited.
In principle, no.
No, okay. It could be more affordable housing is provided under your review, is that right?
That's my understanding, yes.
Yeah, okay. All right. If the affordable housing isn't changed, either before or after 5 years, then what you alluded to a moment ago was very helpful. What you said was that the level of profit could be relevant. What the developer gets, the return, as Mr. Scott puts it, the suitable return for significant infrastructure delivery. What you're saying, I think, is the developer could receive less money than they might otherwise have expected, yes?
Again, out of my area of expertise, what I was trying to say is that it's not just Section 106 would necessarily be the way you look at things. As I said, it could be financing, could be all sorts of things. So it's just a general point is in terms of they may look at other things, not just 106.
Yeah, I mean, there's a statement of common ground. You may not know this about financial viability. In there, it was agreed between Mr. Mitford Slade and Mr. Spilsbury what the developer's profit would be. There was a percentage there, but it was suggested at various times that that might be something that could be reduced. And of course, that's right, isn't it? It could be reduced. The developer could get less profit, but to still deliver the scheme.
Again, not for me, I don't think, in terms of...
Mr. Gearing actually seems to remember he commented on that.
He did, and Mr.
Didn't he?
Dickinson did as well, on that issue about what profitability is doing.
And I asked Mr. Gearing specifically, well, in not... Sorry, and I put to Mr. Gearing specifically, we've got a statement of common ground that gets at a particular percentage. What other figure are you suggesting your client would accept as a lower level of profit? And he declined to answer that. Were you aware of that?
No, I've not. So again, I don't know. Was there a question? Is that just, was I aware of it? Or?
Yeah, were you aware that Mr. Gearing declined to identify any lower level of profit than that in the statement of common ground, which we thought was agreed?
No.
No, okay. The landowners contracts, the deals we haven't seen, there's an earlier version that we have seen, but there is in the viability work a figure that is what we call the benchmark land value. You're probably familiar at least with the phrase.
I'm only really aware of this because I read before this session your notes between what I call the barristers' notes between each other. So
barristers' dialogue, I think it might have been characterised as. Yeah.
So and there was lots on one side and sort of very short response from others. So.
Yes, yeah. Usually in about 10 minutes after I sent it, I think was the response. But leaving that aside, because we're having a very friendly morning.
Yes.
Leaving that aside, what we know is obviously, and this was suggested as well, I think, by Mr. Gearing, is that landowners might not get the benchmark land value. Yes?
Again, I've read it, but I don't know.
Okay.
Well, that's all I've read from the barristers.
This is my point. You're acting for your client, and you obviously want this scheme to be delivered, don't you?
Of course,
Yeah,
and I do planning because I want things to happen. Of course.
Exactly.
Yeah.
And the benefits that deliver, we've heard a lot, and I'm no stranger to this, about the benefits of affordable housing delivery, about the benefits of delivering houses, the economic benefits. The rest of the inquiry, I'm sure, is only too familiar with. That's all predicated on actually achieving delivery, isn't it?
Again, got to be careful though. Again, this is the guardrails of those things because in the the Greenwich decision in terms of those deliverability is not a test about is this scheme deliverable from a Section 38.6 perspective.
Did you say Greenwich or the Wimbledon one?
Wimbledon, sorry,
Yeah,
different,
sorry.
wrong part of London.
Yeah.
Yes.
All I can think of is sport.
Yeah, I don't think it's another decision doing the same thing. So.
Yeah. Yeah, it's fine. I understand what you mean. So the position is, I mean, delivery is important. We'd all sat here pointlessly debating a hypothetical planning permission. Delivery of the scheme is obviously very important, isn't it?
It is, but what do you do with that from a decision-making perspective in the context of the planning legislation, etc.?
You don't waste everybody's time for 50 days or whatever it is, debating something that will never get delivered.
Well, I don't know. Having seen the barrister's notes, it's kind of, there's a difference of opinion on those things in terms of how relevant this stuff is.
But you're here, your clients have invested their money, we've all participated in that, carried out archaeological work, looked at it all, highway assessment, all of that is not for some hypothetical, unviable scheme that never gets delivered. It's all designed to focus on delivering something, isn't it?
Well, it's all about getting planning permission for getting something, and then it can be delivered.
Yeah, and there's no evidence, is there, and you're not aware of any evidence of suggesting any mechanism to resolve the viability issue in the event that our evidence is accepted on that. There's nothing, is there?
Sorry, just answer that. Can you
Yeah,
the question?
there's nothing. You're not aware of any evidence in respect of this proposal that identifies any solution if our evidence on viability is correct.
It's a big if you like, and again, it's not. I don't think
It is a big
relevant.
if, but if
Yeah, I don't think it's relevant.
you don't think it's relevant. Okay, all right. Ms. Bashford, thank you very much indeed. Thank you.
Thank you. Yes, of course.
Right. Right, let's just get them through. Yeah. Right. Just a couple of. Could I just clarify a couple of typos?
Of course, sorry. Yes, I know there's some very minor typos in
I know
there.
it's really minor and stuff, but
No, it's fine. Of course,
I
know
just
there's-
want to make sure I understand.
Yeah, of course.
Paragraph 219, you're talking about the pit stop farm.
Yes.
It's this application, isn't it? There's not more of them, is there? There's only one, is there?
No, there is only one. And again, just two points on that, madam. I think one is, as I say here, that application did consider the cumulative effect of the these proposals, but also I don't know if it's been clarified back to. I think the question was asked about whether the environmental statement considered the pit stop farm ones, and
Yeah.
I don't know if that's been played back to you, but I think Mr. Gearing did check on that, and there is, in response to Pins, specifically asked the question.
Yeah, I think they did.
They
yes.
did, yes, just to sort of clarify. So it's been considered twice, effectively. So
And a pit stop farm consider this one.
exactly, yes. That's I checked in the committee report, and that is the case.
Thank you. Right, thank you very much. 220,
Yeah.
I'm presuming third line down, a deficit of, should it be 119, not 1?
Yes, it is. Yes, not minus. That would be a bit odd, wouldn't it? Thank you.
Now, in terms, and I think Ms Dickinson answered most of, and Mr Gearing answered sort of most of the questions about the way that it's proposed to deliver the site through the master developer model. So am I right in saying that that will only apply to the southern site, not the northern site?
Again, I'm very happy to stand correct and take instruction, but my understanding is that it could be, could happen on either way, if you like. I think the northern one is more typical of the scale that could be delivered by a normal, under normal model, if you like. but I'm very happy to take instruction after.
Just to say that Mr. Gearing, it's relevant to the 106 session at which Mr. Gearing will be, so maybe it might just be one to re-ask, if you like, at that session as well.
Tell me what the answer is.
Well,
so essentially, the 106 sets out a master developer model for both the north and southern application, because there are certain pieces of strategic infrastructures like the Northern Relief Road the master developer will need to deliver. But the financial viability assessment takes a more simple approach on the north, which is a slightly different approach.
And so, right.
So the expectation and the way the clauses are set out in the section 106 are that there is a master developer role on the north as well.
Okay, thank you. Thank you very much. Right, I'll leave it at that. Thank you. Yeah, I mean, I gather you're probably the wrong person to ask, but I'll ask anyway. So, paragraph 3.14, you talk about the northern site and the other land and so forth. We talk quite a lot about council's land.
Yes.
And I think Mr. Young touched on Trenport.
Yes.
So I suppose I could ask, do you know if there have been any negotiations with Trenport yet?
Unfortunately, I am the wrong person to ask. I don't know, madam. I do know, all I've looked at it from the perspective of is the planning permissions. I did sort of input or the first draft of the CD 100s, if you like, in terms of how the planning permissions overlap. But in terms of negotiations, I don't know, I'm afraid. So,
am I going to know from any other source, Mr. Simons?
My mic's on, it's okay. So there haven't been negotiations with Trenport. At the moment, we are reviewing the highway infrastructure that's been submitted by Trenport to make sure it aligns with the section 106 requirements of that application. So that's the main focus.
Again, you're reviewing?
So at the moment, there's a reserve matters application in by Trenport for the first section of the Northern Relief Road.
Yes.
So at the moment, we're focusing on reviewing that and making sure that works in line with what the section 106 requires it to do, to act as the kind of first spur of the Northern Relief Road.
That's a live application at the moment, isn't it?
Correct, yes.
Okay, thank you. I don't think you know that either. Yeah, paragraph 316.
Yes.
You do cover the various tiers, the
Yes.
3-tier process. So I think we did go through the sort of possible time phase.
yes.
So the outline is obviously what we're considering now.
Yeah.
So tier 2 then is more the sort of design code, all the various delivery plans and stuff, strategy documents like I suppose sustainable transport strategy and all that sort of thing.
Yes.
So I mean, have you got any idea how long that would take?
I don't, but again, it'll depend on sort of when things. I mean, realistically, again, deferring again. I suspect it's probably a sort of 6 to 8 month process, because there's going to be quite a lot of engagement with the local planning authority on things like, particularly like design codes, because there'll be a lot of interest in those. There's affordable housing delivery plans, so again, there'd be a lot of close liaison with the local authority on those, and registered providers as well. So.
In terms of the design codes, so did you say that there has been a lot of?
No, there will need to be, in terms of, because clearly the local planning authority were very interested in those in terms of.
Oh, I thought you said there's already been.
No, sorry. So there will need to be at that stage, sorry. So there's some high-level principles in the development specification at the moment, but the design codes will. What I'm trying to say is there'll be quite a lot of engagement at Tier 2 before Tier 2 is submitted. That's why I say 6 to 8
There will
months.
be a lot.
There will need to be, of course, yes.
So, so that none of that work's been done yet.
No. principles and been established in the likes of development specification and obviously some principles in design access statement, but that will need to be progressed. So
presumably once you know what the outcome of the applications is, then depending on what it is, obviously,
yes.
then you get underway with that.
Quite, yeah, exactly. And it's starting to prepare those things. And I have seen some examples from, actually Quinn have showed me some examples of the design codes they've been doing on various other sites. And even for the self-build ones as well, they're quite detailed on some of those things. So they've got a good model of how to do those things.
So do you think that there'll be any work? I mean, in reality, I think from Mr. Young's questions, you're sort of thinking that maybe the Secretary of State's decision with a fair wind might be in summer time, whatever that is.
Yes.
I'm not saying anything. Well, yeah, depends on me a bit, doesn't it, as well? But anyway, say the summer. I mean, would you not do any? Do you think there'd be any work done before that, or do you think it's basically? That's nearly a year, isn't it? Well.
Yeah, I mean, I would be surprised. Clients don't tend to, in terms of obviously it could be abortive work, but but I do think, again, I touched on this with Mr. Young. I do think there can be parallel working on these things as well, because clearly, subject to the grant of planning permission, there would be an awful lot of work on both roads that would need to be done, and then you would obviously discussions, I'm sure, with who would be delivering the homes and everything else, but. In terms of trying to make sure things are aligned, but actually in parallel to that, you've still got then the design codes and everything else that be worked up. So I think what you find is you get work prioritising the critical thing, the roads and the all of the landscaping and everything else that needs to be established very early. There's also things like, obviously, we've got archaeological investigations that need to be programmed and all sorts of things. Again, we'll get into some of this with the conditions. So again, I haven't personally seen the detailed programme, but from experience in other large schemes, it's a lot of that sort of stuff to do, obviously, before you start things. And then it'll be the design codes and the principles at the next stage. But that can be work in parallel from experience as you progress the roads as well, if you like. So,
I see. But you do or you don't think much could be done before?
I think it's a business decision for the applicant, really. So, again, how much of that would be abortive? So, again, Mr. Gearing may be able to answer the question, but from my perspective, I'd be surprised. So,
okay. Thank you. Now, I just wanted to talk a little bit or ask you a few things about the employment proposals. One of the things that's important, I think, is that we've got the Kent Science Park as an existing uses there. And one of the things was the expansion of science and technology jobs, wasn't it?
yes, exactly.
But do you think, but also in order to be flexible, I think you would want possibility of logistics uses and industrial uses also going there.
Yes.
And they would especially like it, wouldn't they? I would have thought, because it would be near the motorway junction.
Yes.
So, I mean, how is it going to... Do you think it's important to actually ensure that some proportion, I don't know what the conditions say, but some proportion of the what's actually going to materialise would be in the science and technology jobs, or do you think it could just be left fluid to let the market decide?
So again, to start in terms of my discussions, when I first got instructed, we had a really good tour round with Pioneer, who run the Kent Science Park. So they were explaining their challenges and everything else in terms of, and we know we've heard them in terms of transport and everything else. But one of the things that they explained was it's not just about the science. Obviously, there's a science-based industries that are there as well. But what they're finding in terms of the constraints they have on there, they can only do the very sort of narrow range of things. They couldn't, for instance, there isn't space and there isn't road access to allow them to, for instance, as well as that science function, expand that to do distribution or actually a bit of manufacturing there as well. So what I'm trying to say, even the science-based things, it's not necessarily being pigeonholed into a very specific sort of use, if you like, to enhance what they do. It's actually probably allowing them to diversify their uses a little bit as well. So just thought let's explain that as a kind of a, rather than saying we're doing this very sort of, we're doing this thing there at the moment, we want more of the things we're doing at the moment. They want to sort of diversify their offer a little bit as well, so that's quite important. So,
but what do you think? I mean, you could imagine being so near the M2 that you could have a whopping great Amazon shed put up there. It would take up quite a lot of the floor space, right near the motorway.
Yeah.
Which wouldn't really, I mean, there might be a need for it, but would it really fulfil the purposes of what, you know, you're actually seeking to do?
Yeah, I think that there is a balance. And again, it's things in the MPPF about the flexibility and allowing things to happen. So elsewhere, there's been things like marketing strategies and things to direct that. But what we don't want to do, I think, is having something that's very, very sort of prescriptive in those things, because you have, to an extent, to allow the market to deliver those things, and the conditions for that are, you know, expanding what's there at the moment means there is a good chance of being able to expand and, as I say, respond to those requirements of those the existing occupiers, and allow them not just to expand their current type of operations but also diversify a bit as well. So there is a balance. I can
We'll have to look at the conditions, obviously, won't we?
Yeah.
In terms of the town centre uses, so I think someone was talking about sort of type of food shops and that sort of thing that could go there. But I mean, would there be any limit on that? Because they're all Class E uses. I understand it. I'm not very au fait these days with the use classes order, I have to say, but I think Class E is, you know, it's very wide, isn't it?
It is, exactly.
So what happens if you get, I don't know, again, near the motorway, you get a out of centre Tesco superstore wanting to get in there?
Yeah, and again, I think we can come back to that at the conditions. That's certainly not, as I said, I think yesterday or the day before, it's not, the intention is not to create a big destination in its own right, and there are, you know, it's very common to see conditions with a maximum size of a food store, for instance, to make sure that that isn't, again, I need to check what's in the conditions, but that is something that could be addressed through conditions. So,
well, I mean, I think if it was anything of any size, there would be the problem of out of centre.
Well, exactly. And as I said, it can't be a destination, but we do, again, you often commonly see it, and even in the Staines Farm development, I can't remember its name now, but it has got a little co-op in there.
Oh, yeah.
Yeah, and it's, you know, we may have something bigger than that if it's subject to granting planning permission, but it's making sure it's appropriate for the community it's going to sit in, isn't it? Rather than starting to create a big destination in its own right. So.
Well, yes, because the actual centres, going then to the centres, I think the centres are something like 1,960 square metres or up to, or something like that, aren't they?
They are, yes.
And I think there's something in the conditions that you could have a food store up to 1,560 square metres, which isn't inconsiderable. It would take up just about the whole of the centre, wouldn't it?
Yeah, again, we can reflect on that and look at that in conditions, but I think it's getting that balance right in terms of it's ensuring as well is that it's commercially attractive as well, because again, I've seen quite a lot of developments where there's been quite a lot of vacancy in smaller units and for quite a long time as well. So part of it's phasing, but also part of it is actually getting the balance right between, you know, not just one big occupier. You do need other services and things there as well. So.
Well, yes, but I mean, there's going to be quite a large population that will support.
Yes, of course.
Or would support it, wouldn't there be?
Yeah.
The other thing I was just wondering about was this hotel.
Yes.
It's not tiny in size. It's not huge, I agree, but I mean, I'm presuming it would be some sort of travel lodge or something.
Exactly. I don't know if you've seen that we did a note in my appendices, and I did do it. I think it's in section. It's section 6 or 7.
Yeah, I saw that.
Yes.
You
So-
compared it with, I think, Discovery Park.
Yes.
Camp Medical Campus. Well, that's got a care home and a hospital on it, so
Yeah.
you can understand they might want to
Yeah.
somewhere for people to stay. Nucleus, that seems to be in Dartford, and the Premier Inn there seems quite a long way away, actually. You know, I mean, I'm just wondering, again, that's town centre use.
Yeah.
That perhaps, you know, I mean, I just wonder who's going to stay there, basically, apart from people using the motorway.
Or Kent Science Park, because that's where
Well,
it's
yes, but who?
Yes.
Because if you get logistics, and that's quite a low. And anyway, they're not going to stay because they'll be driving off places where they're.
No, I think it's, again, I think important to recognise at the moment there is obviously quite a number of employees there at the moment.
Local. I thought it was for local employment, isn't it?
Well, yes, but again, if if you're coming to do business there or visiting there, you may want a hotel. And again, it's also for, again, bear in mind the very long, 20 or so years to deliver things as well. I mean, from my experience of particularly doing things in East London, a lot of the hotels are occupied by people doing the construction element as well. So actually, there's sort of there's the sort of the initial demand, but also the longer term demand when things are fully built out as well, from both residents and from the employment.
Well, unfortunately, the road's got to be open before the hotel's open, hasn't it?
It has.
So
True.
you
That's
wouldn't
true,
get
but there's
construction workers going in there, would
not
you?
necessarily in employment and everything else, though. So, it could come forward in parallel with other elements of the built development as well. So, but I think the thing I was trying to emphasise in my proof of evidence there was to say, look, it's not a massive hotel. It's a town centre use, which I acknowledged, but it is very much serving the local needs, just like the shops are. So,
Okay. You don't think it would be a destination?
not at that scale. It's not a country club like the one sort of north, sort of near the A2, isn't it? Which has kind of got, I haven't been in, but it looks like it may have a spa type thing and other things in there as well. So,
Oh, what are you talking about, Hempstead House?
I think so.
Oh, I know that well.
Okay.
Yeah, it's got a spa.
Okay.
Not that I've been in it, actually, I have to say.
Okay. Yeah.
Yeah, but I mean, things like Premier Inns and travel lodges and things, they are typically used by, people travelling, aren't they? I mean, that's the whole point. They're sort of like short, people go in there when they're travelling and then off they go.
Yeah, true. Although, I mean, this is going to be in the sort of, it's not going to be right off the motorway junction, and it's going, it's close to it. I acknowledge that, but actually, there's a lot of stuff near it. It's not just off the motorway. It's not just off. Yeah.
All right. Oh yes, para 13.8 of your proof. 13.8. Yeah, it was just about this.
Yes, this is the thing that Mr. Dygan sort of discussed. I think.
Yeah, this northern route.
Yes.
Possible northern route, and we saw that there was something in the planning permission that sort of kept.
Yes.
I just wondered if you wanted to comment on that.
Yeah, no, I think fair enough to Mr. Dygan. He is correct. I think 3 points on that. Again, it may be worth just bringing up that. There's two drawings, isn't there? There's the. We can bring up the planning permission, which is 100 and something, which shows. You remember those two hatched areas? One was, I think, it was purple and green, wasn't it?
Oh. I bet you haven't. But for the sake of other people, could you give us a number?
Yes, of course. I'm sorry, because it is.
Where's Mr. Dygan's plan with the hatching? That's useful as well, isn't it?
Yes, it is. I'm just trying to find the planning permission with the hatching in. So.
Oh, he's not here.
I'm in 100. Sorry, inquiry document 100. I'll bring it up. .29.2. It's not quite the same as that Mr. Dyke was explaining, but I think the hatching is the same area.
Oh.
I can bring up the planning commission. That's actually something they appended to the Section 106 agreement.
Oh, I see what you mean.
Yes.
Okay.
So I think the point Mr. Dygan was making was it wasn't just the sort of south-facing arm, if you like, coming down where to the
No.
east of the the homes that are shown on that, wasn't it? So what he was showing was that it was kind of, it has that sort of a kind of diagonal, potentially could go in that diagonal further to the east. But just so that was the first thing. What I wanted to show then, though, is the document which we've been to, I think, a few times over the last few days, or this week anyway. I think it's CD 15.14.
Yep.
Do you remember the plan right at the back of the PDF?
Okay.
The 3 routes on there.
Hold on. Oh, I think that is the one I've got in my copy. Yep, carry on.
So that is different, and I think Mr. Dygan did acknowledge that. So it's different from what has actually been considered, if you like, in terms of an option, but it does look, so I'm not sure that it's actually been tested is the first point I wanted to say, because it's
When
not.
you say it's different, sorry, what's
Yeah, so this is why I want to get the 2 plans up. If you've got hard copy, that's probably the correct way of doing it, actually. So if you bring up the, where I was before, 129.2,
Yep.
if you again, it's quite confusing, isn't it? Because we've now got houses to the west of where that sort of arm is, if you like. So if you can imagine where that's coming over the railway is where effectively near where those houses are. That's a sort of southern alignment, isn't it? So, and then, but what you've got there is you can see Mr. Dygan's version is it goes south more quickly. It's a kind of a sharper diagonal than the northern route shown, because that's what he was saying. That technically, you can still go on the northern route, but that they changed that. Do you remember the discussion? He was talking about a church, wasn't he?
Yes, that's it.
Yeah. So he was saying they've in discussion with the conservation area, I think he said that they changed that, so it was going. I think it was going sort of more south quickly, if you like, to kind of avoid the church. So that was the first point. It's different from that assessment. So that's what the first point I was trying to make is I don't think that's ever been properly tested, if you like, in terms of where this safeguarding actually does it work. The second point is if you've still got the 1514 open, or we've got the hard copy.
Yeah.
We had a discussion, I think it was on Wednesday, about paragraph 3.51 in the, so I've only got hard copy, so it was that discussion about the different routes and the costing of them.
Paragraph 3.51 in what?
Yes, it's the.
Oh, yes, it
Yes.
was that
Yes.
agenda, wasn't it?
That's right. It's the Swale Joint Transport Board, 14th of March 2011.
Could you give me the CD number?
Yes, it's 15.14. I think that's.
Oh, it's still in that
yes,
same. Oh,
yes.
right. Yeah,
That's
okay.
This plan is at the back of it. The thing. So, and then we had a discussion about the northern route. I think it was looking at it here, paragraph 3.51 of that, showing it was £46.5 million. So more than twice any of the other options.
Yeah.
So there was a whole. I think there's a whole point about it's a different. It's something that's never been tested. Point 2 is if it is a northern route, which even if it's kind of similar, the only evidence we've got is it's an awful lot more expensive. I think the most, from a planning point of view, and as a planner, this is kind of the way I look at it. I think the flooding issue is absolutely fundamental, though, because again, I think this was mentioned in passing.
Yeah.
I think it was on Tuesday, wasn't it? So just going to documents that are actually in the CDs. I think if we go to CD 1.13. can see that's a sequential test. Sorry, CD 1.13, madam.
Yeah, I know. Yeah.
If you go to the second page, and there's figure 2 there.
Oh, yeah.
Can you see the flood mapping all the way kind of north of the railway? So,
Oh, I see, yes.
so huge flooding issues in terms of north of the railway, and that's consistent with those wider diagrams we've seen. If you remember the strategic constraints, if you like, of the SPA and the flood risk and everything else, effectively to the north of the railway is where that really starts. So again, and I'm presuming from the purpose of MPPF, that will be critical infrastructure, if you like, if you take that northern route, and that causes lots of problems, both even in terms of feasibility of trying to design something to address that, but also in practical terms about actually the risks associated with putting a road through the floodplain. And just for my own purposes, madam, again, I'm very happy to produce this. I did actually check. Do you remember the flood maps changed earlier this year, didn't they, in terms of the Environment Agency issued updated flood maps earlier in the year? And again, just looking at, I just checked those, and that does corroborate, hasn't changed very much at all since then.
We haven't got those as evidence, so.
No, we haven't, but just to sort of, it doesn't change anything. This was done I don't know when this was actually done, but for my own purposes, I just checked it. So figure 2, if you looked at the flood mapping from the Environment Agency's latest website, it really just corroborates broadly what's on that plan.
Okay. Thank you very much. Yeah. Okay. Paragraph. Hold on a minute. What am I doing here? I'm sorry. 13.11.
Yes.
You say you're talking about Frogner Farmhouse and the heritage.
Yes.
Yeah, the heritage harm. And you say, as Dr. Mealy explains of his evidence, he disagrees with the historic England position, which attributes a low level of less than substantial harm.
Oh, I may have got that wrong.
You've got that wrong, haven't you?
Yeah, I think I have, haven't I? Yes.
It's at the upper end of the spectrum.
Just look at the table opposite. Yes.
Yeah.
Apologies, I've got that wrong.
So that is a
yes,
bit of a...
just a typo.
Yeah. Okay.
Yes, upper end they say, don't they? So.
Yeah, they do.
Yeah.
And, oops, hang on, sorry. And paragraph 13.19.
Yeah.
You talking here about the southern scheme and harms arising from it.
Yes.
And you say in paragraph 13.19, the final sentence, my view is that the public benefits of the northern scheme.
Oh, right. Sorry, yes, that's
Do you mean southern scheme?
I do. Sorry, yes.
Yeah. Okay.
Thank you.
Thank you.
However many times you read these things.
Well, I've only read it once and I've picked them up.
I did. Yes. The authors are often blind by their own writing.
Well, that is true.
Yeah.
Yeah, I'll take that comment. So we've talked about viability and Mr. Dygan does seem to imply, actually, in his 13.8 of his proof. Let's just
So turn that up.
up, yeah. Yeah, if I can find it.
13.8.
Yeah.
Yeah. Sorry.
Just a sec. 13.8. Just a moment. Yeah, he says there. Oh no, that's not what I wanted to ask. Hold on a minute. Oh no, sorry, 13.38. Sorry. Oops. Yeah, he's talking about. Let's go back to this town centre use.
Yes.
And he says, town centre uses would be out of centre in the location proposed, with the quantum of space proposed there. There is the potential to adversely impact demand. Well, in other words, impact town centre vitality and viability.
Yeah.
So is it important then that we look carefully at the conditions to make sure that that's not going to happen?
Yes, I think so. I think it is all about making sure that each of the mixed-use centres is appropriately scaled, but as we were discussing earlier in terms of, microphone, and also just making sure that the units themselves aren't disproportionately sized within that.
Well, I think it was more on the science park, actually.
Yeah, that's odd, isn't it? Because
Talking about-
again, we may need to look at something that, again, we touched on this on Tuesday, I think, didn't we, or Wednesday? I think, I don't think the intention is to have loads of shops. There may be some placemaking elements to things, as we discussed on Wednesday, but I don't think there's any intention to suddenly start having lots of shops in there.
Well, I mean, you quoted, which one was it now? I think it's nuclear. No, it might be. Oh, no, I think it's a Discovery Park, actually, which looks as if it's being built, actually, at the moment. I don't know if it's been completed.
Oh, right, okay, I don't know.
But anyway, what it has got is got several fast food takeaways,
Oh, yes.
as far as I can see.
Yeah, no, that's not the intention, I don't think so.
So...
Yeah.
Sort of drive-through type places.
Yeah. So very happy to look at conditions,
Wait,
madam.
you shake your head, but I mean, that is a possibility, isn't it?
It is, but yes, I think we need to get the balance right. So.
Yeah. Okay. Yes, Miss Bonnie. Now I need you to turn to her proof next.
So I can put Mr. Diggins away now. So
I think you can. Yeah.
thank you.
Yeah. The last 2 points are her 2 points she
Okay.
makes. It's like your comments on. First of all, on paragraph 10.6.
Sorry, just
Sorry.
give me a moment. Sorry, 10.6.
Yeah.
Yes.
She talks about the promotion agreement, doesn't she? Which is CD 10.80. No one's mentioned this. But basically, and I wonder whether you've got any comments on it.
Sorry, 10.6. This relates to the Shell land, does it?
Well, it's basically a promotion agreement between the applicants and various landholders. I'm assuming to...
I think, I haven't been at all sessions. I do think we did have some form of, may have had some discussion. Let me just bring the document up.
I don't know whether we did actually bring it up.
This is the one that's lapsed.
Yes.
But contains about 150,000 per gross acre.
Sorry?
Mr. Gearing was asked about it. It's the 2017 document that isn't extant. It's not.
It's
Well,
expired.
It's not extant. It's expired. That's what I mean. It's expired.
So I did ask about it
Yeah.
because
Who did you ask?
I think
Just
Mr.
ask?
Gearing.
Gearing.
Mr. Gearing was asked about it.
Oh, well, right. Well, that's fine then. I'd forgotten that. You asked Mr. Young, did you? Okay. But it's expired anyway. Right, I'll look through my notes, that's fine. But yes, and the only other thing, again, you might tell me that this has been asked already as well, but she talks about, in 11.3, she talks about the concern about lack of consultation with Southern Water, doesn't she? I wondered if you got any comments on that.
I did ask about this question because Ms. Bondi did bring it up in terms of things. So I think part of my understanding from this, when I read all of the documents and the applications, because we went through the various, I think it was about water. It was actually about water rather. It was all about new water, wasn't it? So my understanding was actually Southern Water they actually were part of that. They informed those studies, if you like, or that feasibility study initially. So it's kind of integral to the actual what was shown in there. So. And again, I think the other comment was that Miss Bonnie made was that isn't that out of date? Because I think that study was probably done in 2018 or 19, because it was, I think at the time, that was when the applicant was going through or starting to think about going through the local plan process, if you like, in terms of doing those new settlement submissions, and that's why it did it at that early stage. But again, what we've got is, I think Southern Water involved early in the process and actually helped do that feasibility study, but then we've got a series of consultation responses from them as well. So if they were concerned, you would have thought they would have raised them as they're going through the actual consultation process. So.
Yeah. Thank you. That's it. Thank you very much.
Okay. Thank you, Madam.
So it's just re-examination. Have you got any? You haven't got any.
I don't. Thank you very much. Which means that then is, can I say it? I think I can. That is the applicant's case.
Gosh, right. Okay.
Just got to get writing now. We've got to get writing first. We've got to do our closings.
Get writing first. No.
No, thank you very much. That's
Thank
all of the evidence in this inquiry.
Well, thank you all very much. It's a sort of, well, gosh, it's a bit of a moment, isn't it?
Yeah, it does feel like a moment.
Right, so we will adjourn now then, and so we're going to resume those who are involved on Monday week at 11. Okay, 11 o'clock will start, and we're going to have 2 days, you'll be pleased to know, about conditions. I will do my best to try and get, as I said, something track changed in advance. It won't be that much in advance, I'm afraid. But we need to make sure that we've got those up-to-date conditions. Yeah. So can they be submitted today, please?
Yeah, I think that's yes.
In time for the programme officers to actually forward them. Yeah.
That is the plan.
That's all right.
That is the plan.
Okay, and in terms of the Section 106 agreements, are there any updated version? I think there was an updated version I was going to have, wasn't there?
You are due it, and I think we indicated lunch. You said lunchtime on the 13th, which is Monday. So
Lunchtime on Monday, I think.
Lunchtime on Monday.
Right.
Mum, could I just raise a point about water? Because I think Councillor Bonnie was just saying to me she's concerned that you were talking about the wrong water company when you had that exchange just now.
I mean South East Water. I meant South East Water, right. Let's just ask that again. Thank you, sorry.
Sorry, to answer on South Eastern Water. Again, I've asked the question, and I understand from Mr. Gearing that they didn't respond to consultation responses. And again, I think from reading the feasibility studies, they were involved from that. But when I asked the question about, well, I'm not sure why they haven't responded. They just didn't respond. And I do think there was correspondence, and even Mr. Dygan, I'm very happy for him to confirm, did chase them up, but didn't get a response. So.
Okay. So you think Mr. Dygan chased them up?
I believe so, yes. But again, that's what I was told. So again, I haven't spoken to him directly about that.
So we don't actually have any consultation response from South East Water then?
Not South East Water, no. Not what I've
South
seen.
East?
Yes. Yes.
Yeah. Who are the main water provider? Yes. Well, it's sort of divided, isn't it?
Yes, that was the discussion the other day, wasn't it?
All right, thank you. Thank you very much. Right, so Monday lunchtime, the updated Section 106, which must be forwarded to everybody and programme officers. And the conditions, they're coming. So what did you say?
Today, I think we said.
Oh, right, okay, there's conditions today. Okay.
Sorry, when was the Section 106 document
Lunchtime on Monday.
that you're circulating?
That's the plan. Keep your eyes on. Keep refreshing the inbox.
I look forward to it.
All right, is there anything else anyone wants to raise before we go?
No, thank you very much.
All right, so I'll see those of you who are involved on Monday week at 11 o'clock then. Thank you.
Thank
The
you.
inquiry's adjourned till then.